I'm calling the Board of Adjustments meeting for July 10th, 2025, Marvin, the Village of Marvin, to order. We have a quorum. We're going to start with...
Just a quick note, we are missing Ken Marino, one of the regular members, so one of the alternates will be stepping in.
We have two alternates, so have you flipped a coin yet?
We will do that when we get to the case.
Perfect, okay. We are going to move to the adoption of the agenda. If I could get a motion to approve as presented.
I make a motion to approve the previous meeting minutes as...
No, adopt the agenda.
adopt the agenda, I'm sorry.
Get off your phone.
I was trying to silence it. That happened last time.
Yeah.
I make a motion to approve the agenda as presented.
All in favor? All right, so moved. We are also going to be adopting the previous minutes, which are not technically our minutes. So there's really nothing that we can change except to approve them and move forward. So if I could get a motion to approve those minutes from 2020. Is that the year?
22.
2022.
Mm-hmm.
I'll go ahead and make a motion to approve the previous Board of Adjustment meeting minutes from 2022.
And all in favor? All right, so moved. All right, since this is our first Board of Adjustments meeting, we do have to elect officers.
So just like Planning Board, Board of Adjustment has chair and vice chair with a one-year term. You all may elect whoever you choose to be chair and vice chair. We, at a staff level, we do recommend you keep it the same as Planning Board. So if someone would like to make a nomination for either position.
I'll make a motion for Kelly to be the chair.
All right. Did you get that?
Somebody has to second it.
So, okay, John has nominated Kelly for chair.
Oh, you can't second.
I'll go ahead and second the motion.
Any other nominations? Okay, now I need a motion for that. Or if you want to go, let's go and do nominations for both, and then we'll do one motion. So what about nominations for vice chair?
I make a nomination for Richard to be vice chair.
Any others? All right, can I get a motion to elect Kelly Cates as chair and Richard Holzberg as vice chair of the Board of Adjustment?
So moved.
John?
And all in favor?
Aye.
I guess we can still vote. I don't know.
Unanimous. Okay, you're good to go on.
All right, we're going to be moving on to the hearing of the cases. We have one this evening, appeal hearing of an administrative decision by the zoning administrator submitted by Robert Epps, Maria Epps, and Robert Eric Epps, LLC. Who starts?
Jake, would you like to open with a preliminary statement? Sure. We'll get to that.
Good evening, everyone. Tonight, Mr. Epps and Ms. Epps have appealed the decision, violation of an ordinance, and the way this is going to go tonight is the chairman is going to give a very brief summary of what's occurred so far that's brought us here today, and then each side is going to have an opportunity to present what their side of the story, their arguments, the facts. Those who stand up and testify are going to be placed under oath. It's going to be a quasi-judicial proceeding. If there are witnesses that have additional comments that they'd like to make, they can ask to come up and make statements as well, and it'll be determined whether or not those statements will be heard, if they're relevant or appropriate. And anyone that has standing pursuant to the statute may also come up and present evidence. Once all of that occurs, the board will discuss amongst themselves whether or not the appeal should be, or the lower decision shall be overturned or upheld, and then a decision will be released, or a decision will be made tonight or within 48 hours, and then within 30 days, an opinion will be written and an order will be delivered.
So I don't believe
Jake,
I've
would you
been
actually
given a
mind-
summary.
Would you actually mind giving the summary? I want to make sure that.
I believe that the applicant could do that, and I mean, the village can do that. We spoke with the appellant briefly about more relaxed rules than having the village do the background, and then let the appellant speak, and then let any of the public that has the right to speak, to allow them to speak, and then a brief closing from the village and then the appellant, and then we move on.
Great.
And my name's Chaplain Spencer. I'm the village attorney. We have several attorneys here. The board has a separate attorney in Jake, and then the appellants have their attorney as well. And with that, we can kind of move forward if you're ready.
Yeah, we're ready.
First thing we need to do is, since we're going to be presenting first, we need to get you sworn in.
Do you solemnly swear or affirm that the testimony that you are about to give during this hearing is the truth, the whole truth, and nothing but the truth? So help me God.
I do.
Yeah, well, just state your name and position.
Hunter Nestor, Planning Director for the Village of Marvin.
And do you have direct knowledge of the facts of this case?
I do.
Did you post signs of the Board of Adjustment hearing along the property?
Yes,
Did you do that between 10 and 25 days prior to the hearing?
I did.
Did you notify adjacent owners?
Yes, they were also notified via mail.
Okay. Do you have a copy of the agenda packet?
I do, right there beside you.
Is that a true and correct copy of the agenda packet before this board?
It is, yes. Everything that was included in their packets.
Okay. We'd like to move this into evidence, just to formally do it, which I'd hand up if there are no objections. And now, since you have the facts, I'm going to be quiet and let this move forward in an efficient manner.
Okay. Ptolemy, can you pull up my presentation, please? You got it? All right. Yeah, next slide, yep. So this is an appeal hearing from an appeal received from Mr. Robert Epps and Ms. Marissa Epps, who are the property owners of 517 Pacer Lane, as well as Robert Eric Epps LLC, the owner of 516 Pacer Lane. They have filed this appeal of administrative decision for a notice of violation that was sent by the village. The two subject properties, as mentioned, are 516 Pacer Lane and 517 Pacer Lane. Both properties are located in the Marvin Estates subdivision. Next one. Yep.
And we've also been informed that the sign portion of the NOV that's not been appealed. And so that's not before you. The applicant has agreed to comply with that. So you're focused on the other issue. Yeah, please.
It was appealed, I believe, we may let the student appeal, but we are not withdrawing.
Thank you.
So a little background. On or around April 26, 2025, a solid fence was installed across the full length of Pacer Lane between 516 and 517 Pacer Lane. On May 14th of this year, the village sent a notice violation citing multiple violations of the Marvin Development Ordinance. One of those being the determination that the property owners were in violation of 2.13-2 of the Marvin Development Ordinance. That violation was sent to the property owner on 5/14. On June 6th, Mr. Bo Cottle, on behalf of the property owners, submitted a letter as written notice of appeal in reference of why this hearing is being held. And once again, the top right is just an overview of the property. You can kind of see from here. In orange is the approximate location of where the fence was installed. The bottom picture is a picture taken of the fence and then gate going across Pacer Lane. This is just another picture of reference in front of 517, noting when the sign was posted, as well as you can see in the background the fence and gate going across Pacer Lane there. This is another photo taken from the intersection of Joe Carr, looking up Pacer Lane. This is a photo in front of 516, once again noting that the sign was posted, as well as in the background you can see the fence going across Pacer Lane. And here's just another photo, once again seeing the fence and gate fully encroaching across the Pacer Lane. So supporting documentation, so the notice of violation was issued by me, who is the planning director and code administrator for the Village of Marvin, due to failure to comply with two sections of 2.13-2. The first being 2.13-2 is references fences and walls. A zoning permit must be issued by the planning and zoning subdivision administrator for all fences and walls. The process of that is outlined in Article 7. The property owner failed to obtain a zoning permit per those requirements in Article 2.13-2 prior to installing that fence, which then furthermore violates Article 23.1-3 of the MDO. Furthermore, the property owner failed to comply with Article 2.13-2G of the MDO, which states that fences shall not be erected over easements such as, but not limited to, access easements, utility easements, drainage easements, or any other public easement without the explicit approval of the Public Works Director and Planning Departments. If fences or other barriers are allowed to cross such easements, the village engineer may require the installer or landowner to install gates or other access points per standards and specifications set by the village engineer to ensure access to such easements in the future as necessary and minimize damage to private property. The owner failed to consult with the village regarding erecting a fence over the publicly dedicated public easement known as Pacer Lane. The access easement is documented in the recorded plats for the Marvin Estate subdivision, and specifically the subject properties of 516 and 517 Pacer Lane. This supporting documentation shows that the deed for 516 Pacer Lane references the property as Lot 3A on 3 different recorded plats. The first one being the one dated November 26, 1998, and recorded in Plat Cabinet C, page 259, and was recorded on December 12, 1998, or 1988. It references Pacer Lane as right-of-way and is dedicated for the public use per the signed ownership and dedication certificate that you see on the bottom right there. It was then again referenced in a lot line revision of 516 Pacer Lane that was dated January 17, 2002, and recorded in Plat Cabinet G, page 811, on January 22, 2002. It references Pacer Lane as a public right-of-way. It's also noted that the streets are dedicated for public use again in the top left there. Furthermore, there was another lot line revision done in December of 2002 and recorded in Plat Cabinet H, page 384, and references the Pacer Lane as a public right-of-way as well. Ooh, go back. Again, the deed for 517 Pacer Lane references the property as the following, which is just Lot 3 of all of Block E, as recorded in Plat Cabinet A, file 37A. That shows Pacer Lane as a platted road connecting Joe Carr and Chestnut. Is there anything else you want to mention? Or?
Is that all you've got?
It is, yep.
I've just got a few questions for you before I turn this over. Do you interpret the structure across Pacer Lane as a fence?
I do.
What about the gate aspect?
I do.
But no, I mean,
Or
explain.
the gate's attached to the fence. It's still a physical barrier, which that section references fence and barriers and walls. And so that was all taken into consideration as part of my interpretation of that section.
Okay. Do you maintain that Pacer Lane is a public right-of-way or easement?
I do, based off the information in the recorded plats that were just referenced.
Is your interpretation that MDO 213-2 even requires that the easement be public?
Sorry, say that again.
Does MDO 213-2, which is the,
Go back.
pull it up if you want. Yep. 213-2, does that even require that the easements be public to enforce?
It references any other public easement, but it also references access easements, which are for access for surrounding properties or private individuals that have the right to access the easement.
Okay.
If that makes sense.
And why is this MDO section important?
It's important because it ensures proper access across for the property owners of the subdivision to use to access their property.
Okay. And was there an application to install the fence?
There was not.
And how could the appellants cure the violation?
They could either abate or remove the fence, or apply for a zoning permit, but like I said, that was, in my interpretation, would still not be granting the zoning permit.
Okay, and was that instruction included in the NOV, the abatement?
It was, the property owner was instructed to abate the violation, so to remove.
Okay, I have no further questions, and please answer questions from either the,
Quick question, we do need to designate which alternate is participating. Do you mind if we go ahead and do that really fast?
we've got alternates?
Yes, because you're missing one regular member. We're going to flip a coin to see which alternate participates tonight. Angel, would you like to call it?
Sure. I'll take heads. You will. Tails.
So Mike will be participating tonight as the alternate, stepping in for Ken. You're good. Thank you.
Okay, Mr., is it Nestor?
Yes.
Mr. Nestor, we've exchanged emails, but I don't think we've ever met. It's
Nice to meet you, yes.
meet you. My name is Bo Caudle. I represent Robert Epps, Marissa Epps, and Robert Eric Epps, LLC, and I just have a few questions for you. Just going back to the beginning, when did you first hear about the fence that was constructed over Pacer Lane?
On or around April 26th of this year.
And how did you hear about it?
We were notified via just, I guess, some chatter. It was the date of the Marvin Day celebration. And then received emails from some of the adjoining property owners the week after, asking, what can be done, and the complaint was received, and then that led the village to issuing the notice of violation.
All right, just so I understand, you say adjoining property owners. Adjoining what?
Adjoining as in the members of the subdivision,
The members of what subdivision?
Marvin Estates.
Marvin Estates. Okay, so members of Marvin Estates emailed to complain about the fence over Pacer Lane.
That's correct.
But just to be clear, property owners, they may or may not have had property that actually adjoins Pacer Lane, right?
I don't know off the top of my head. I would have to go back through.
Fair enough. Okay. When did you first go out to physically observe the fence?
Prior to the notice to be being sent.
I would certainly hope so,
Yeah.
but do you know when you went out to observe the fence?
Not the exact date, no.
Okay, can you ballpark it for me?
It would have been probably the week before to document and then review the ordinance and, once again, determine if it's a violation.
Okay, thank you. And I'm just going to check real quick, because I do not remember the date of the NOV off the top of my head.
It's May 14th.
So you think it would have been right around May 7th is when you would have went out?
Yeah, that week.
By the time you went out, was there already a gate there?
I believe so.
Okay, so a gate had been constructed. It was not just a fence all the way across the road. It was a fence and gate.
No, but when we were first notified about it, it was just a full-on fence across the road.
When you first saw it?
First notified about it.
Yeah, so just to be clear, I'm talking about when you first observed it. When you first observed it on or about May 7th, it was a gate attached to a fence.
That's correct.
Okay, thank you. Did you attempt to open the gate?
I did not.
Did you observe whether the gate was locked?
I did not.
Okay. You mentioned at the beginning of your testimony that as part of your preparations for today's hearing and as part of the requirements under the ordinance, you provided notice of the hearing to certain property owners, true?
Yes, all adjoining property owners basically all property owners within 100 feet of both subject properties.
All property owners within 100 feet of both subject properties, and the subject properties are 516 Pacer Lane and 517?
That is correct.
So do you have a list of the people who received notice?
I do. I can provide.
Do you have that with you?
I can pull it up on my computer.
That would be great.
I can pull it up. Would you like me to print for the record?
That would be, if you don't mind, that would be lovely.
Can you
Yeah.
grab this?
Hunter, you can connect on that side too if you would like. I can disconnect it.
You know how my computer is.
Okay.
You can email it to me,
I can, yeah.
and I could read it. Oh, you can read?
That'd
Yeah,
be
you
good.
just read it into the record. That's
Okay.
totally fine.
So the properties would you like the mailing address, the
The
property
name-
owners?
The names
Okay.
of the owners.
Robert Eric Epps LLC, which is the owner, or the mailing address was 517 Pacer Lane.
And let me just real quick, as you're going, I may ask you a couple questions. Okay, Robert Eric Epps LLC, do you know who owns that company?
I do, based off of, do you want to state it?
Go ahead.
Robert Epps, based off the information on the state website.
Great. And you mentioned that's the owner of 517 Pacer Lane?
That's the mailing address for that. The subject property that's referenced is the Elysian Fields Common Open Space that
Okay.
the entity owns.
Okay, keep going. Sorry to interrupt.
Mary Marquez, mailing address 505 Marvin Road, and owner of 505 Marvin Road. Robert Epps and Marissa Epps, owner and mailing address 517 Pacer Lane. The Estates at Marvin Branch Homeowners Association, which their mailing address, based off the tax card, was not an actual address, but I can read that. It says copy to Hawthorne Management Company. Mary Leslie, 505, mailing address 505 Marvin Road, actual address 511 Marvin Road. It's again Robert Eric Epps LLC, mailing address 516, owner of 516 Pacer Lane. Barbara Amy Clausen, mailing address 516 Pacer Lane, owner of 9801 Joe Carr Road. Robert Patrick Ranthel, I might probably butchering that. Mailing address 9718 Chestnut Road, owner of 9718 Chestnut Road. It's again, Robert Eric Epps LLC, mailing address 517 Pacer Lane, owner of 1014 Helena Court. William R. Lyles and Robbie S. Lyles, 9807 Joe Carr Road, owner of 9807 Joe Carr Road. Leslie Ann Ferguson and Michael Maurice Ferguson, 524 Pacer Lane, and that is the owner and mailing address for that. And then finally, the Estates at Marvin Acres LLC, mailing address 6401 Carmel Road, Suite 202, Charlotte, NC. Owners of the common open space of the Sage and Marvin across Joe Carr.
Okay, thank you. Now, those people all received notice because their property line is situated within 100 feet of the subject properties?
That's correct.
Of either of the subject properties?
That's correct.
Okay, so those people may or may not have property that adjoins Pacer Lane, correct?
They would? I mean, they would more than, if that's what you're asking.
In other words, there are some of them who may have property that touches Pacer Lane, but not all of them.
That's correct.
Property that touches Pacer Lane. And then just for the sake of being clear about why, if you could go to the second page of the supporting documentation that Mr. Nestor provided, should be an overhead view of the properties. There, yeah,
Okay, yep. Right here.
yeah, perfect, thank you. So you can see the two subject properties outlined in red on this depiction, is that correct?
Yes.
And then in between them, that's Pacer Lane, true?
Yes.
And Joe Carr Road is at the top,
Then, yep,
and Chestnut is at the bottom.
that's correct.
Now, between Joe Carr Road and Chestnut, I count 1, 2, 3, 4, 5 properties that actually touch Pacer Lane. Am I right about that?
That is correct.
Okay.
On
and
that portion of Pacer, yes.
On that portion of Pacer, and on that portion of Pacer, Mr. Epps or his company owns 2 of the 5, right?
That is correct.
Do you know who owns the other 3?
The other 3, based off of the information I just read, I would have to double check with GIS to make sure that I am saying the right. But if you
Yeah, it's
give me
okay.
one sec.
If you don't know, I don't know is perfectly fine.
It would be the Leslie Ann Ferguson and Michael Maurice Ferguson of 524 Pacer Lane.
Okay.
It would also include Barbara Amy Clausen of 9801 Joe Carr Road, which that mailing address is 516 Pacer Lane. And it also would include Robert Patrick and Tanya Berge Rand, I can't say this, RANFTL of 9718 Chestnut Road.
Great. Okay. All right. Now, you testified a little bit about the existence of your conclusion that there is a public right-of-way or easement over Pacer Lane. I want to ask you just a few questions about that, okay? Let's start with the plot maps that you've referenced in your report. So if you could go to those. And I actually want to start with the one at the very end.
Okay.
I believe it's the very end. Yeah. That's right. Okay. You mentioned on this slide, this is the plot for that was attached to the deed for 517 Pacer Lane. So when Mr. Epps and his wife bought this property, they bought subject to this, or with reference to this.
To this plat, as for their meets and bounds description, correct?
Now, this map doesn't say public right-of-way on Pacer Lane, right?
It does not.
And you don't say it does. I just want to make sure everybody understands. There's no reference to any public right-of-way on this map that Robert and Marissa Epps referenced when they bought their land, right?
Yes.
Okay, and you're not aware of any other map that was referenced on any deed subsequent to this that referred to Pacer Lane as public right-of-way with respect to an acquisition by Mr. Epps or his wife?
No, I did not look at the previous deed prior.
Okay. And we don't have that in front of us in any event. Okay, now let's go to the other ones. So this deed, and again, this is not a deed, this is a plot map, but it was attached to the deed through which Robert Eric Epps LLC purchased this property, right?
That's correct.
And the property description references this map, true?
It references 3 plats, and this being one of them, yes.
Okay. Now, this particular plot map shows Pacer Lane plotted with a right-of-way, a public right-of-way. But the deed has a certification on it from the owner indicating that the owner owns the property depicted on the deed and that the depiction of that property is true and correct, right? I'm summarizing, but it effectively says that.
Yeah.
The property depicted here, though, if you look at the title, is section number 4, and I've got a bigger copy of it here. This might be helpful for folks. Can I pass this out? There we go. And oh, I'm sorry, just because you're. Yeah, you should get tails. You know, tails actually Okay, I'm going to pull it up on my computer here. So if you look at that deed in the top, kind of in, on this screen, it's not blocked. It's a little blocked on the report. Give me just 1 second. Okay. So it says that it is in reference to section number 4, block A. Do you see that? Marvin Estates revised plot, section number 4, block A. You see that?
I'm seeing,
Yeah, that's the first page. Sorry. I should have told you. Go toward until you see that in there. It's this one, I think.
okay,
All right. It says section number 4, block A, correct?
correct.
Okay. So whoever submitted this particular survey or had this survey done, they didn't own anything other than section number 4, block A, true?
I don't know if I can speak to that. I'm not sure.
Well, you've spoken a lot about a lot of deeds today, so my question is, they say they own the property referenced on the deed says section number 4, block A, that's all this deed is about, is that true?
No, because the deed specifically states lot 3A of block A.
Well, yeah, that's the subdivision, but it's referring to the property, section number 4, block A, the property of B. Irvin Boyle and Josephine M. Lewis trustees. You see that?
Yes.
Okay. And the reason I'm asking that is because whoever created this survey and sold a plot or a piece of land subject to this survey could only sell what they owned. You agree with that, right?
Yes.
And they would have only owned half of Pacer Lane, right?
Yes.
You ever heard of the dedication of half of a street to the public?
I've heard of dedications of easements on property.
You ever heard of dedication? My question was, sorry, have you ever heard of the dedication of half of a street to the public? Have you ever heard of that?
No, because in short, the state statutes have changed of how things will get platted. This was platted in 1975. Or specifically, the first plat was in 1975. This was in 1988. Most of the time, deeds read to the center line of the road, even on North Carolina's maintained and state roads.
Exactly. So this deed is to the center line of Pacer Lane. Even if it purported to create a public right-of-way, it could only do that with respect to half of Pacer Lane going to the center line, right?
Correct.
Okay. Do you know if that dedication was ever accepted by anybody?
The village wasn't incorporated at that time, so it was not accepted by us. Other than that, it would have been NCDOT, and not to my knowledge.
Okay, so no, you don't know whether it was ever accepted by anybody?
Correct.
Okay. Do you know whether NCDOT maintains Pacer Lane?
I do know NCDOT does not maintain Pacer Lane.
Does the Village of Marvin maintain Pacer Lane?
We do not.
Okay. So Pacer Lane is a private road?
It's a privately maintained road, yes.
Just private road, that's what it is, right?
It's a privately maintained road.
Okay. Why are you fighting with me about private road versus privately maintained road?
Because in my opinion, there's a difference between right-of-way and the actual road.
An important difference?
Significantly, yes.
One that if it existed, you would want to make sure you explain to anybody who was asking you, is this a private road or not?
Yes, I do it all the time.
You would be very clear, it's a privately maintained road.
Yes.
Okay. So I'm going to show you a document that was produced to me today, coincidentally, by the Village of Marvin in response to a public records request that I sent. Give me just 1 second. And before I do that, actually, can you just tell me, who is Christina Amos?
She is the village manager.
Okay, she's your supervisor, right?
That is correct.
from Ms. Amos to, give me just one second, I'm gonna pull it up so that I don't misstate it.
Is it your intent to introduce these materials into evidence?
Yeah, I'll mark them once.
Okay.
I mean, I don't really know if my case in chief or how that goes here, you know?
Yeah.
I'll mark them at some point. Okay, so anyway, Mr. Nestor, here is Christina Amos, your supervisor, telling a member of the public that Pacer Lane's a private road in response to an inquiry. True?
That's correct.
She doesn't say privately maintained road versus private road, right?
That's correct.
Have you ever made any such similar statements to members of the public?
Like I said, anytime especially with this road, I'm sure there's some residents that can attest to this, that I say that it's a privately maintained road.
One second, apologize. All right, Mr. Nestor, I don't have a copy of this. I'm sorry, everybody. I'm just going to have him read it so that you can hear it, okay? This is just part of the public records production. Okay, Mr. Nestor, this is a document I received from the village today. You were asked to go find records that I had requested, true?
That is correct.
And you put that together and you gave it to the village clerk for production, true?
That is correct.
And this is an email dated May 1st, 2025, so about 6 days before you went out and observed, give or take, the fence. And it's to someone named Amelia Helms.
Who is the district engineer for NCDOT?
Okay, and you say, it is our understanding that the fire marshal has issued a notice of violation to have it, referring to the fence, removed, right?
Mm-hmm.
Pacer is a private road, right?
That is correct.
Okay, so you don't say privately maintained road, right?
I do not in that email, no.
Okay. All right. Who is Davey Broom?
He is the Public Works Director of the Village of Marvin.
What's his responsibility for the village?
He is the Public Works Director, so he oversees I really don't want to misspeak on everything that he does, but he oversees that department, which includes streets, facility maintenance, stormwater, sidewalk, all of the above.
Okay. I just handed up an email from Mr. Broom concerning Pacer Lane. You see that?
I do.
This is in response to a citizen's inquiry about Pacer Lane. You see that?
Correct.
He says it is a private road.
He does, yep.
Okay, so that's you, the planning director, the public works director, and the village manager. All seem to agree it's a private road. Yes?
Like I said, it is a privately maintained road.
Yeah, right here it's privately maintained, but in your emails, it's private. It's a private road, right?
In my email to a member of NCDOT, yes.
Okay. And in Ms. Amos's email to inquiring member of the village or resident of the village?
That's correct, but I will mention that I am sworn in to enforce and interpret the ordinance, and so, once again, privately maintained road.
Okay. And again, all of your evidence that this is a public road, as I understand it, or that it is not a public road, but a privately maintained road subject to a public right-of-way, am I putting that correctly?
That is correct.
Okay. All of your evidence of that is this plot map, which refers to public right-of-way for half of Pacer Lane, and the plot map on the page prior to that, which does the same thing, right?
Yes, the three plats referenced for this specific property, all reference it as a public right-of-way.
So a surveyor surveying a subdivision of Marvin Estates for the purpose of a sale of a portion of the property within Marvin Estates that does not even include the entirety of Pacer Lane between Chestnut and Joe Carr, happens to write public right-of-way on his survey, and now it is a public easement over the road? That's your interpretation?
That is correct.
Even though the person who did that did it for someone who doesn't own the whole road?
Like I said, I'm using what is recorded at the Register of Deeds office to make that interpretation.
Well, you're using specifically, and I'm not trying to nitpick with you, but you're specifically using this plot map, the other plot map we just talked about, and then the plot map for Mr. Robert Epps's property and his wife's property that doesn't refer to it as public road at all, right?
But it also doesn't refer to it as a private road.
I'm sorry, was what I just said correct? I just want to make sure for the record.
Yes.
Okay, great. Now, do you have, well, and I just, the packet that you handed up, that's all of your evidence today, right?
Yes, everything that was included in their packets was everything that was used for this case.
Right, you don't have any other evidence to present to the Board of Adjustment today other than what's in this packet and what your attorney may ask Mr. Epps about?
That's correct.
Okay. All right. You talked about the ordinance, just so everybody can look at it with me. Wanted to make sure I had this right. This is the portion of the ordinance, specifically, I think it's 2.13G. That you say prohibits the construction of a fence over Pacer Lane.
Correct.
Okay, and G says that you can't build a fence over easements, including but not limited to, and then it lists several, including an access easement. What's that? What's an access easement?
Access easement's defined as, and then pretty much that it's that someone, members, property owners have a right to access through the property.
Can an access easement be given by a private property owner to another private property owner?
I believe so, yes.
Okay, I think you're right about that. All right. So, almost done, I promise. You testified to this, but I just want to make sure everybody understands. So, in your view, even if Mr. Epps had submitted a permit application, that application would have been denied because of 2.13G?
It would have had to been reviewed further to ensure that proper access for either, in my opinion, EMS or any property owner and that have viable access. So it had to be reviewed further as outlined. It had to be consulted with Public Works Director and the village engineer.
Okay. Let me make sure I understand that. So even though the fence was built across Pacer Lane, had Mr. Epps submitted a permit, it's possible that permit would have been approved or could have been approved?
It could, maybe, depending on what was submitted and how it was designed, yes.
If he shows, for example, that certain property owners still have, I think, did you say reasonable access? Is that what you said?
I don't recall saying reasonable, but
Okay, well, what requirements would he have to satisfy then in order to have the permit approved?
in any sense, if this was a subdivision being gated, I would refer to consulting with Fire EMS to make sure there's adequate and proper safety for response times and such. I would also be making sure that all property owners that have a right to access and use that road have adequate access to it, either through a code system, key system, something. That's what we kind of follow. What I'm trying to say, sorry. That is what I've used in other determinations to say for other properties.
Okay, so there are other properties where someone has constructed a gate, for example, over what you would consider to be a right-of-way or access easement or ingress-egress easement, and the village has approved that construction?
Yes.
Okay, where?
There is 5 lots across from the park on Newtown Road that installed gates for their development.
Okay, and do those gates operate automatically?
I believe so, yes.
All right, and by automatically, I mean when the car drives up, they open, assuming you have the correct access code.
That's correct.
All right. So anybody driving there, they would have to stop, input the access code, and then they can go through the gate.
Like I said, I don't know that specific, if it's an access code or gate, but I was ensured that all 5 of those lots have access on top of, with a zoning permit and electrical, they have to get a building permit with Union County that triggers review by multiple departments of the county, which one of those typically are going to be fire and EMS as well.
Best of your recollection, has the village ever denied someone's permit application once it has been determined that the gate sort of satisfies county requirements like fire safety requirements?
Not to my knowledge, one has not been denied.
All right, let me show you something else. Mr. Nestor, are you aware that the county, through the Office of the County Fire Marshal, sent Mr. Epps a notice of violation of the state fire code related to the construction of the fence?
I am aware, yes.
And do you know what the status of that is at present?
I do not.
You don't know what the status of that is at present? You ever participated in a conference call with county attorney, Mr. Williams, county fire marshal, Ms. Amos?
I did not.
Quick point, Mr. Cottle, when you're away from the mic, it's probably not picking you up. They're pretty sensitive. They're not very sensitive.
People telling me to be quiet. I'm sorry. I will make sure to talk into the thing. I apologize about that. I'll represent to you, sir, that's an order that was entered in a case the county brought against Mr. Epps, his wife, and his company related to the fence. Can you go to the last page of that order? And in this order, Judge Perry, Superior Court judge, ordered that the county's motion for an injunction be granted, but did not order Mr. Epps to take down the fence or gate. Instead, simply ordered him to leave it unlocked or to automate it. Do you see that?
I do.
So at least as far as Judge Jonathan Perry is concerned, there is no threat of safety threat posed by that gate, at least as it pertains to the fire code, right?
Yes, that's how I would understand it.
Okay. And then if you look up that page a little bit, paragraph 2, Judge Perry wrote, defendants Robert E. Epps and Marissa I. Epps own 517 Pacer Lane, located in the village of Marvin. Defendant Robert Eric Epps, LLC, owns 516 Pacer Lane, which is adjacent to 517 Pacer Lane. Defendants' parcels include that portion of Pacer Lane, a private road adjoining their respective parcels. You see that?
I do.
All right. The fact that the court, at least, has determined that there's no fire code issue here, that's something you would consider in determining whether or not to issue a permit?
That is correct.
I would ask that somebody direct the room to be quiet while we're doing this. For those of you who all things to say, ask to speak later, but while there are folks on the stand who can comments themselves. Okay. Now, what else, other than that, what else would go into your sort of discretionary decision making? You mentioned the ability to get through the gate, sort of how it operates.
Correct. And in any other sense too, depending on the location and setback from any type of state maintained road, making sure that there's adequate either stacking or turnaround and so on, would go into my determination. Yes, this one is set far back, but those are factors that go into when issuing the permit.
Yeah, fair enough. And you mentioned setbacks from state maintained. There is no, the closest state maintained road would be Joe Carr, right?
That's correct.
Okay.
I'm sorry, could you repeat that, please?
The question was, the closest state maintained road would be Joe Carr.
That's correct.
Thank you, sorry about that. Okay.
You might want to use that microphone respectfully, because it is very difficult
Okay. All right, thank you again.
Yeah, guys, I appreciate the comments, but if you all have comments, we can't hear.
Yeah, it's the village, I went and checked, he's talking into the mic, it's the village's system. We need to work on that, but it's not his fault, he's speaking into the microphone.
Austin, could you please turn up the interior volume, if that's possible?
How's that? That's not any better. Yeah. Hello? Thank you. Testing. Okay, great. Okay, Mr. Nestor, I promised you I was almost done a second ago, and I am. My last question, I think that at some point after the notice of violation was received, Mr. Epps actually asked you about whether he could submit the permit application and whether that would take care of the problem, and you told him that no, the violation of the ordinance with respect to the easement would still exist. In other words, the permit wouldn't help. Did you tell him that?
I don't recall. I mean, I would have to look at my email. When he emailed me, I was on vacation, so I'd have to go back and look.
Okay, well, hang on one second. Okay, Mr. Nestor, I just handed you an email that is a response that you sent to Mr. Epps in regard to his inquiry about submitting a permit application. You see that?
I do.
And in it, you tell him it wouldn't solve the problem. I'm paraphrasing, but it wouldn't solve the problem, right? You still have the easement issue.
Based off the information I had at the time, like I said, it would have not met the determination.
Well, and what information was that, I guess, is what I'm curious about.
Once again, there was a physical fence and barricade across the road. As I previously mentioned, did I check if it was locked? No. So based off of the, once again, high-level information that was presented by Mr. Epps, as well as during my visit to the site, a permit would have not been issued. Now, I'm not saying that he couldn't have provided the information needed.
Okay, well, that's where I'm getting a little tripped up, because your email doesn't tell him, hey, submit your application, I'll review it, right? It says it's not going to fix the problem. True?
That's what this email says, yes.
Okay. But if Mr. Epps were to leave here today and submit a permit application that, for example, described the gate, told you that it was unlocked, told you that the Superior Court of Union County had made determinations that it could remain in place without violating the fire code, maybe that would affect your determination as to whether...
Like I said, if this application was submitted with all applicable requirements and the supplemental information needed, then yes, it could be reviewed at that time.
Okay, all right, thank you, Mr. Nestor. I believe those are my questions for you, sir.
I've got a few follow-up real quick. Did you testify earlier that MDO Section 213.2 applies to both public and private access easements?
Yes.
In your experience as a planner, do certain third parties have rights in subdivision streets that are not dedicated and accepted by the public?
Yes.
Does the Village of Marvin and its MDO have provisions that apply to both publicly accepted and non-accepted streets and roads?
It does, Article 13.
And does Article 13 have any provisions regarding connectivity and flow of traffic?
It does. All streets to be constructed are supposed to be interconnected for a comprehensive network to create interconnectivity, but either for the internal subdivision as well as connectivity to primary roads such as state-maintained roads, Marvin Road, Newtown, and so on.
Thank you.
Okay, just for clarity, the position that you're taking, that particular section of the ordinance applies to private easements, that's a legal conclusion, yes?
Sorry, say that again?
I mean, it doesn't say specifically it applies to private easements, so you are relying on a legal interpretation of the ordinance that maybe a court or judge could disagree with, right?
It states that all provided that non-state maintained streets within the Village of Marvin and for streets proposed to be maintained by the village.
Yeah, I'm not talking about that section. I'm talking about the easements section, the section specifically cited in the notice of violation. It says that a fence shall not be constructed on an easement, including but not limited to, and it lists several. We talked about that, right?
Yep.
And it ends with this phrase, any other public easement, right?
Correct.
Okay. So you're interpreting that section to mean that any easement at all, private, public, that's your interpretation, true?
That's correct.
And all I'm saying is that's a legal interpretation. This board could disagree with that interpretation. A court could disagree with that interpretation, true?
Yes.
Okay, that's all.
Have any questions? Anyone on the board have questions for Mr. Nestor?
Hunter, when you did a search for the records that stated Pacer Lane, or when you were looking for those plats, any other records that stated Pacer Lane had a public right-of-way, did you stop your search after you found a certain amount? Like, is it possible that if you went back and searched, you would find additional documentation?
I pulled the plats for those subject properties. That subdivision was platted in different phases. The whole subdivision as a whole was platted in different phases, so I'm not sure what other plats said. I was only focused on 516 and 517 Pacer Lane. So those were the plats that the deed referenced, and those were the ones that were pulled.
And can a property owner that owns to the center of a street deem it private if someone on a different part of the road, the same road, has a public easement on it? This is what is confusing, is what parts of the road can people make decisions on?
So for example, I can say for a fact that the property located on the corner of Joe Carr and Marvin Road, their deed reached the center line of Joe Carr Road. But Joe Carr is a public road, it's a state maintained road. DOT's not here to say if this were to happen there on the stance they would take, but that is an instance of where, yes, deeds, especially in older subdivisions, read to center lines of roads.
And are there any utilities, any types of, anything that's run along Pacer that other folks would need access to if this access was cut off, besides the flow of traffic?
There is a power easement, I believe, on 517 Pacer Lane. I am not 100% sure if there's power running along Pacer Lane. I would have to go look. I can check the photos. But I do know there is a power easement that runs from Pacer Lane to through 517 and then across Marvin Branch to the Elysian Field property. I believe it's also referenced on that deed.
And is my knowledge of, so my personal experience has been, if there are any issues with deeded plats, if a homeowner, property owner has an issue with a deeded plat and something states that it's registered with the deed, what are those people called? Sorry. What? Thank you, good Lord, said it all around it. So if a property owner or a surveyor submits something to the Register of Deeds and it is incorrect, it is upon the property owner to then hire a lawyer to go into the courts to have it changed. Is that correct? Does anyone?
That's yeah, it would be a civil thing or a real estate, a real estate law thing to have that corrected.
So what you see here is, in all intents and purposes, if it says it's a public easement, that is what the Union County Register of Deeds sees as the truth.
That, yes, in my using that in my interpretation, yes.
Let me just ask one question, Hunter. Has there been a change in Union County as to where iron is placed to demarc a property? Because, for instance, if I look at mine, I know where it is in the back and in the front. It's about 4 feet in from the street. So has it changed? Because here we're looking at something that's in the middle of a road, which doesn't make sense to me why it would be there. So has there been a time where Union County realized that that was a mistake?
Planting to the center line?
Yes.
I don't have that history. Like I said, that.
So was it just common where that was just the easiest way to do it? Just in the road, but you couldn't build into the road if you wanted to. So if I wanted to put my swimming pool halfway into a street, or if I had a 5-foot or setback.
Yeah.
But I'm just trying to figure out why this iron happens to be in the middle of the street where so many others are off on the side of a road.
Like I said, I don't have that formal answer. If you look at a bunch of older property, and this is probably even throughout North Carolina, a lot of deeds read to the center line. Either could have been a portion that a state came through and did a road or took over a road, something. But I don't know when or the full history of that.
We were looking at the document you gave us from the Superior Court. And in the conclusion, it says, the plaintiff's motion for preliminary injunction shall be granted, and the defendants are ordered not to erect, maintain a fence, non-gated, gated obstruction, or other locked obstruction across Pacer Lane. But that's not what you were saying. You were saying he was not told he had to take it down.
It says he can't have a locked gate there right now. That's it. That's all it says. So the gate that's there is not locked and is therefore
It says not to
allowed.
erect or maintain a fence, non-gated obstruction, or.
That's locked. Locked, right? He can't lock it. If he locks it, he has to automate it. That's what that order means. And just for the record, I know that rules of evidence here are loose, but I do have to object to consideration of testimony concerning what a lot of deeds show and, why there may not be a pin in the center. I appreciate Mr. Nestor has a lot of experience interpreting the local ordinance as a planning director. I'm sure he's qualified to do that. I'm not sure that he is qualified to answer legal questions about what deeds do and do not accomplish or achieve. That's it.
I'll also note that the language of the order is somewhat confusing to me. I could read it two ways, but one, it's only a preliminary decision. The case is, it's a preliminary injunction, it's not a final determination.
Jake, am I allowed to ask a question of the Epps?
Well,
Point, or is this
once-
only on the testimony?
if the Epps are called up to testify, which it sounds like they may be, then I think that would be the appropriate time. If there's no further questions for Mr. Nestor,
I've got a question, and, things may have changed. But based on the information that was provided to us in that big package that, went out with the, to us to review, photographs, showed the fence with the gate in it and everything, but there are also signs on both ends of Pacer Road, Pacer Lane that said road closed, no access, or dead end. How does that fit into that? I mean, on the one end of Pacer, it's right there in the middle of the fence or the gate.
The notice was only sent for the actual structure, the fence and gate that was erected across the road. Those signs that were placed weren't taken into consideration during my notice of violation. But they're there. I'm not going to speak on behalf of the applicant, but they're there.
Chaplain, you have anything further, or is Mr. Nestor?
No, we don't.
Okay. Mr. Caudle?
Do we just share the microphone?
Does that work for you, Bo?
Raise your right hand. Do you solemnly swear or affirm?
Or if it's, I could switch over there if you'd rather be here.
I'll do that. Thank you.
Go ahead and tell everybody your name, please.
Robert Eric Epps,
Mr. Epps, where do you live?
517 Pacer Lane, Marvin, North Carolina.
Who lives there with you?
My wife and 2 daughters.
Who owns 517 Pacer Lane?
My wife and I do.
Do you also own a company called Robert Eric Epps, LLC?
Yes, sir.
Does that company own the real property at 516 Pacer Lane?
Yes, it does.
Robert, we're here today about a notice of violation you received concerning a fence you constructed on Pacer Lane. Is that correct?
That's correct.
Robert, tell me about Pacer Lane. Why'd you build a fence over it?
Pacer Lane has always been a private road. A lot of neighbors have discussed closing it over the last 10 years. More recently, in the last year or two, there was additional discussion, actually unbeknownst to me until I got a letter, but suggesting maybe closing Saddle and/or gating the end of Pacer Lane. Does that answer your question?
What specifically were the issues that were spurring those conversations about closing Pacer Lane?
So Pacer Lane and most of Marvin Estates has suffered through the fact that it's a 2-entry and another, what we'd call the back entry, going to Joe Carr. It's open, so we've had crime. It's easy in, easy out. The roads are not maintained. There is no HOA. I heard reference to an HOA earlier. There isn't one. There's no covenants now, as far as I know. The village has always maintained that it's a private road, even when I was on council. And we developed the road acceptance program. There were several roads that were not eligible, and Pacer, Saddle, and Chestnut were amongst those roads because they're private. As far as I know, it's never been considered for repairs, improvements. The specific issues now is the culvert where we put the fence is collapsing.
Let me just jump in for a second. When were you on village council?
Gosh, I think it was 2015, 16, 17, and around that time.
And during that time, council discussed Pacer Lane from time to time,
Yes,
and whether it was public or private?
yes.
And what was the position that council took?
It was private and not eligible for PAL funds.
Okay, you were telling us about a culvert. Go ahead.
The culvert that goes from 516 to 517 is on my property. There's a hole, the pictures, if you could pull the pictures back up, it might be a little easier.
Do you mind putting up the report, Mr. Nestor's report?
Unless there's a way for me to show photos.
Yeah, I don't know if if we'll be able to broadcast them.
Okay, that's okay.
We could?
We would need,
Okay, great.
get this presentation back up in 1 second. Sorry about that. Can you just tell me which slide you want to go to?
There were some actual pictures of the gate.
This was the first.
Yeah, you're on them. So there should be a closer one I thought I saw.
Hunter, do you still have the clicker?
If you could go to the next slide. Go back. So on this slide, it's hard to see it, but past the road closed sign, which by the way were put up so people weren't get frustrated. They serve no purpose to me. It's just keep people from getting frustrated. There's a hole right behind that sign. Water percolates up and under the asphalt through the culvert. Where the park bench is, the culvert starts. It follows the fence. It's just a foot away from the fence to the other end. There's a depression, which you used to be able to see when the school buses would go over it. They would catch air, and it's been getting worse over the years, partly because of the increased traffic. We on the section of Pacer see up to 500 cars a day before it was closed. The other issues, when I talk about crime, where the trees overhang, especially here on the right, where this corner property and my property meet, heroin needles have been found, condoms, of course beer cans, the normal stuff, but the needles are disturbing. The house in the corner was broken into. Not everyone in the neighborhood may know that. It's during busy times, 2 rows of traffic may come through. One of the catalysts for starting this was the last couple of road rage incidents where every time we try and pull in our driveway, they pass us on the left, and it actually turned into a thing. So the culvert and the condition of the roads, could you go back to the previous slide? You can see the grass and the cracks and all that here, but if you go to the previous slide, none of these are great representations, but if you look at the pavement, that's what the whole road looks like. Probably the whole neighborhood, but I do know that section there, that's what it looks like from Joe Carr all the way to Chestnut. There you go. I just wish you could see the hole where the culvert is sinking.
Do you have,
And Robert, you mentioned you have photographs of that on your phone, right?
I do.
Hang on 1 second. Chaplain, do you have any objection to him showing people those photographs?
Which photographs?
The photographs that he has on his phone of the collapsing culvert? He can email them to me so that I can actually put them into the record later. Do you have any objection to that? Depending on-
Bo, do you mind grabbing my glasses?
I don't.
By now you think I would remember them. Thank you. So it's similar photos to what's up there, it's just close-ups?
That's fine.
Okay.
Did you say you don't have an objection?
No objection.
You want me just to walk it around?
I'll have Robert email this to me after he shows them to everybody, so I can actually put them in as an exhibit. I'll just email them to you and the clerk, Austin, if that's okay. And then, yeah, Robert, if you'll just go around and show everybody the pictures.
Bo, do you plan to go through some of the pictures with him as well?
Probably not. I'm probably just gonna let him show them and have him.
I would say after, if you have questions to ask, you certainly can, but I think it'd make more sense to let Mr. Caudle finish his line of questioning and if Chaplin has any follow-up. So if you've got some, write them down, so you don't forget them.
Okay, Robert, what issues, if any, does the potential collapse of that culvert pose to people traveling over Pacer Lane?
Well, they could be harmed if it collapsed under them. Most recently, we had logging trucks coming through for sage development, which the Village of Marvin was able to help me stop because we're on private roads. The sheriff also was able to no trespass them because we're private roads. The culvert, should it collapse, it's gonna take somebody's tires off anyways. I'm more concerned about kids on e-bikes, foot traffic, what the general public may not understand, but I think most residents of Marvin Estates understands, is because we own to the center and there's no HOA, and there's no Village of Marvin, and there's no DOT, there's no entity protecting us, we are liable. So I am liable for that culvert. I'm liable for a kid face planting from hitting that ditch line or that pothole. And if Marvin were to determine it was a public right-of-way and easement, I would still question then who is going to take on the liability.
Robert, before you constructed the fence across Pacer Lane, did you make any effort at all to talk to your neighbors about that?
Yes, I actually, like I said, we've been talking about this for 10 years, and then it was brought up again 7 years ago. Whenever a certain resident may have an issue, it turns into a discussion. But once I saw the letters from the people on Saddle Ave, and the road rage incidents, and then the culvert, it was time, and the fact that I bought across the street made it easier to do, because then I owned the entire road. So all the adjacent property owners, we discussed it. One of them actually brought it up. I was still resistant, but when they brought it up, I thought, okay, let's talk about it. I talked to my wife about it. So then we talked to the other neighbors that attached the road, and they all agreed it was time.
Are you able to show the slide that has the overhead depiction, satellite image again, of Pacer Lane?
Was it one that was in?
Is
It's the one with the red outline, yeah. There you go, that's it right there. So Robert, you can kind of see that in the top right-hand corner of the slide. The property depicted on the right of the slide, that's the property you own with your wife, correct?
Correct. The triangle of sorts.
The property depicted on the left of the slide with the red outline, that's the property that Robert Eric Epps LLC owns, correct?
That's correct.
Okay. And then there are only 3 other property owners whose property actually touch Pacer Lane. Who are they?
The one on Joe Carr is Amy Rojas. Here on this corner is Mike Leslie, and he's here. On this corner is Bob and Tanya Runful.
And a second ago, I asked you about the number that touch Pacer Lane. Right now, I'm talking about the stretch between Joe Carr and Chestnut. Over Chestnut, there are additional properties that touch Pacer Lane, correct?
On this side of
Yeah, coming down the picture.
Yes.
And if we were to continue tracking down the picture, eventually Pacer Lane comes to a T intersection with Saddle Ave, right?
That's correct.
Okay. And Robert, what, if anything, did you do to secure your neighbor's agreement to or approval of closing the road?
We all signed a road close agreement.
All right. Robert, I'm showing you a document that is marked as A6.
Yes.
What is that?
That's the road closure agreement.
And if you could flip to the back of it, please, the tail end of it. Is your signature on that agreement?
My signature is on this agreement.
Did your wife sign the agreement?
She did.
Who else signed the agreement, Robert?
Ronald and Barbara Boone. Barbara Boone is Amy Rojas. This is her legal name. She remarried, so her last name is now Boone. Robert Ranful, Leslie Ferguson, Michael Ferguson, Peter Voigt, Vivian Voigt, Kathy Spain, John Spain.
Did those folks sign the agreement in your presence?
Excuse me?
Did they sign the agreement in your presence?
Yes, sir.
And has anyone, since that agreement was signed, has any other owner of real property in the area expressed their approval of you closing the fence?
Yes.
Who is that?
Billy and Kathy Earnhardt, which is the triangle property to the right. I don't know everyone's last names. Mary, who owns the corner of Chestnut and Marvin Road. The folks that are building the new house on the corner of Chestnut and Pacer, I haven't spoken to directly, but they have shown support. With a whole map, I could probably do better. The Spain zone, the next property coming down Pacer, down on the left where the corner of Pacer and Saddle meet, she reached out and showed support. There's a person on Saddle that showed support down at the end. I didn't query everyone, but those were people that actually told me that they were for the closure.
After you built the fence, when you first built the fence, it was a fence that stretched all the way across Pacer Lane, true?
True.
And you received a notice of violation from the county fire marshal, is that right?
Yes.
What did you do in response to that notice of violation?
He said a gate with a cuttable chain would satisfy their needs, so I installed one.
And then after you installed the gate with the cuttable chain, what did the county fire marshal do, if anything, with respect to the notice of violation?
The automation was added to it. They desire automation.
So you were notified it had to be automated,
I was notified it had to be automated.
specifically automated siren sensor Knox box had to be installed. right?
Correct, those three things.
And you didn't do that, right?
It's not in the fire code, so I did not do that.
And so the county sued you, true?
True,
And that lawsuit's still pending, right?
correct.
Okay. And what is your understanding of what is going on in that lawsuit presently?
Currently, the state fire marshal is investigating the local fire marshal. The judge ruled, and you've previously touched on it, that it actually says something to the effect that if desired. So right now, it's my understanding, as long as I leave it unlocked for the fire department, there's no need to automate it.
Let me show you what I've marked as A4. And actually, before I do that, just very quickly, I'm going to move the admission of A6, which is the agreement that he just testified about.
Can we submit a
Hey,
copy?
wait for
Yeah,
for him to look at it. You can, if you want to, why don't you just pass that down, let everybody take a look at it, and then I'll grab it from Jack, if that's okay. We'll give everybody a second to look at that. Okay, and I also just emailed Austin the photos of the culvert, so you should be getting those, okay?
Thank you.
Okay. I handed you a document that I marked
Yes,
A4. That's the Superior Court's order on the county's motion for preliminary injunction, is that right?
that's correct.
And that order was entered on June 17, true?
True.
To your awareness, has the county filed any motion for contempt or other motion alleging that you are in violation of that order?
No,
To your awareness, are you in violation of that order?
no.
Robert, you heard some testimony about the road, well, strike that. So after you received the notice of violation from the county, you received a notice of violation from the Village of Marvin, right?
That's correct.
All right, what did you do in response to your receipt of that violation?
I didn't receive the violation. I heard about the violation from the attorney opposing us in this case,
Kelly Cope, is that right?
Kelly Cope. So I reached out to Christina Amos, the town manager.
And what did Christina tell you?
She, I believe, was on vacation, so she sent me a screenshot of the first page of the notice of violation.
All right, what did you do after you received that?
I reached out to you.
At some point, did you reach out to Mr. Nestor about the violation?
Yes, I emailed Mr. Nestor and asked what it, I told him I wasn't aware of it. What was this about?
All right, I'm going to show you a document I've marked A1. Is that an email exchange that you had with Mr. Nestor?
Yes, it is.
And in that email exchange, Mr. Nestor told you that a permit would not solve the problem because of the easement issue. Is that right? It's in the first email, first page, Robert.
Oh, yes, it says a fence permit will not correct the first violation.
Okay, so I'm doing a poor job of this. Let me back up for a second. A4, I'm going to move to admit A4. That's the Superior Court order. I'm also going to move to admit A1. That's the email with Mr. Nestor. Robert, if you believed that your permit application could be approved, notwithstanding the easement issue, would you submit one?
Yes.
What else, if anything, do you want to tell the Board of Adjustment today, Robert?
Once the neighbors and I determined that we wanted to try to fix what was wrong with what was going on in our neighborhood, once we all talked and collectively signed the road closure agreement, I did take the steps to call 911 so they can update the CAD system. CAD is what first responders read as they go to a site. My wife's a paramedic, so I knew that. They don't read GPS, they read CAD. It's right in their trucks. So I reached out to 911 coordinator of Union County. I reached out to the schools. It's been reported I didn't. I did 2 weeks prior. I reached out to the Village of Marvin, and Christina and I know each other. And I was letting her know, knowing it's a private road and that the Village of Marvin wouldn't be involved. She confirmed that. She said they don't, I believe her exact words, they don't have a dog in the race.
This is getting into testimony about somebody who's not here, and I'm going to object under hearsay.
Gotcha.
I don't think the hearsay rules apply to this proceeding. I think that the only limitation on the receipt of evidence is whether it is relevant and material to the matter at hand.
So, well, I think it's ultimately up to the board, but that is correct. So generally, evidence should be allowed in as long as it's relevant and it's not duplicative, so it's ultimately up to you if you're willing to listen to the evidence, but that's what the rules require. So if you believe that what he's testifying to is relevant and it's not duplicative, then it should probably come in.
Continue, please.
She did mention that, like I said, she said they don't have a dog in the race. I said, I understand that. I have a history with the village, so I knew it. But that I wanted her to know. This is Christina Amos,
Christina
the
Amos, okay.
village manager. Later, either in that conversation or the next conversation, she did mention a fence permit, but she said it was no big deal and it was a $25 fee. That was my understanding of, and she said there was no rush. That was my understanding of the village's only involvement. In addition to that, I contacted the post office and whoever else was involved. Some reached out directly, some did not. I did start trying to contact other neighbors after about 6 calls with no callbacks. I stopped. So.
Okay, Robert, just some cleanup real quick. Handing you documents that we discussed during Mr. Nestor's testimony. A5 is the Marvin Development Ordinance, including the section related to fences over easements. Do you see that?
Yes.
I move to admit A5. Then A2 is an email that was produced by the Village of Marvin in which Christina Amos told a village resident that Pacer Lane is a private road. Do you see that?
I do.
I move to admit A2. Any objection to that?
No.
Okay. And then A3 is an email from Davy Broom, the Public Works Director, to a resident of the Village of Marvin, indicating that Pacer Lane is a private road. Do you see that?
I do.
I move to admit that, A2 as well.
No objection.
Those are my questions for now. Yeah, that's it. That's it for now.
Mr. Epps, I have a few questions for you. Are you aware that the Village of Marvin passed a road acceptance policy after you left the village board?
A new one?
Yeah.
Because we had adopted one when I was
Yeah.
there.
Are you aware that they amended and adopted a new road acceptance policy?
I wasn't.
Have you petitioned for the village to accept Pacer?
No.
Pacer Lane? Okay. Are you aware that NCGS 160A299 has expressed provisions for closing roads?
I am not.
Okay. And with that, will you read the highlighted section of that statute?
NC ST 168-299, Section D. This section
Yeah, the highlighted, thank you.
shall apply to any street or public alley within a city or its extraterritorial jurisdiction that has been irrevocably dedicated to the public. Irrevocably? dedicated,
Irrevocably?
Yeah.
dedicated to the public, without regard to whether it has actually been opened. This section also applies to unopened streets or public alleys that are shown on plats but that have not been accepted or maintained by the city, provided that this section shall not abrogate the rights of a dedicator or those claiming under a dedicator pursuant to GS 13696.
And have you petitioned village council to close this road?
I have not.
Okay. And you mentioned discussion with adjacent owners. Did you seek approval from these persons prior to putting the fence up across Pacer Lane?
The ones that signed the road closure agreement, yes.
And what about other persons?
I attempted to contact around 6.
Okay. And have you ever presented that agreement to the village council other than tonight in this, or to the village planner other than tonight?
I have not.
Okay. And if you look at Pacer Lane up there, do you own all of Pacer Lane?
I do not.
But yet you drive across portions of it to get to your house, correct?
Correct.
So you have a private easement to cross that to get to your house?
I do.
That's all I've got.
Yeah, the state, yeah. Okay. So the statute you were handed, Robert, is 168-299, procedure for permanently closing streets and alleys. And the language you read said the provisions of this subsection regarding division of right-of-way in street or alley closings may be altered as to a particular street or alley closing by the assent of all property owners taking title to a closed street. Do you have signatures from everybody on the stretch of Pacer Lane that is closed?
Yes.
The next provision that you read is, this section shall apply to any street or public alley within a city or its extraterritorial jurisdiction that has been irrevocably dedicated to the public without regard to whether it has actually been opened. Robert, have we seen anything today to indicate that at least the 517 side of Pacer Lane has been irrevocably dedicated to the public?
No, not at all.
And are you aware of whether any public entity has ever spent a single dime caring for or maintaining Pacer Lane?
No, never.
Those are my questions. Thanks.
Mr. Epps, how long have you lived on Pacer Lane?
22 years,
22.
approximately.
And during that time, where cars drive through Pacer Lane, maybe as a shortcut from Joe Carr to get on Marvin Road?
Have they? Yes.
Yeah. Did you notice that Lori Haggart wrote, and she said she uses Pacer Lane because she feels for new drivers it's dangerous to make a left on from Joe Carr onto Marvin Road?
I have her email. Do you want me to read it?
No, I have. I mean, you saw it, right?
I didn't read it.
Oh. Your
I read the
counsel
part.
entered it as...
Let him answer the question.
I will.
I read the portion from the Marvin manager. I didn't read her email.
Do you want me to read it to you?
But I can. I can read it.
Okay, go ahead.
I've read it.
Okay. So you're familiar that, you understand that people were using that for that reason, or is this something new to you?
Using it for mobility to drive their
Yeah,
cars?
instead of
Yes.
going all the way up to Joe Carr and making the left there, they'd make a left on Pacer and then make the right.
Oh, yes, I'm
You're-
aware.
You're familiar
Yeah.
with that, right? Okay,
I'm
good.
sorry, I didn't understand what you were asking.
That's okay. You said you were on council for 4 years,
3 or 4 years, yeah.
maybe 3 years, and the last year not so much?
Excuse me?
I said maybe 3 years and the last year not so much?
I'm not picking up your last
That's okay.
question.
Now, you said that while you were on council, council discussed private and public road of Pacer, correct?
Correct.
And they weren't available for POW funds. Did you have an opinion on that? What was your stance on whether it should be private or public when you were on council?
I believe I said publicly that I believed our neighbors and I liked the fact that we had no HOA and we had private roads.
So you didn't want any POW funds to improve that road? You were against it?
It wasn't an option.
Well, you said you discussed it.
It was.
So if you were discussing it and you,
I'm sorry, he needs a chance to answer the question, sir. You can't just keep interrupting him. Let him answer your question.
you're interrupting me when.
Well, I'm voicing an objection.
Go ahead.
And just for everyone speaking, this is being recorded, so it's just best practice for everyone. Let folks finish answers, let folks finish questions. That applies to everyone across the board.
Repeat the question?
You said while you were on council, you discussed about Pacer Lane being a private road and that it wasn't eligible for POW funds. I just wanted to know if you campaigned or tried to lobby your fellow council people to make Pacer part of the village so it could be eligible for POW funds?
Advocating for my own road, I thought was unethical.
Okay, so your answer is you did not ask council to make it a public road and eligible for public funds?
No, part of the road agreement we were working on, and I believe it still stands, is in order to be accepted, you had to bring it to standards, which right now would mean digging down 13 inches, coming up with 10 inches of stone and 3 inches of asphalt. I'm guessing it's a couple $1 million project just for the village to take it over, at which time now Union Power could come down the road because it's public. Any utility could come down the road because it's public. The loop, the village has asked me permission to come down with the loop. Previously, I said no. If it's public, they don't have to ask. Nobody has to ask to do anything if it's public. Right now, this is a measure of protection for the entire neighborhood, whether they realize it or not. But should it ever be determined that it's public, we give up a lot of rights. So at the time, did I advocate? No, it wasn't appropriate. Would I have advocated even if it was? No.
So the reason you said your fellow or your neighbors, you're closing it for safety reasons.
It's one of the reasons, yeah, it's probably
What are
that-
the other reasons?
liability.
Liability, okay. Did you guys ever discuss about, the safety reasons? You showed us that picture. Did you guys ever discuss about repairing the problems that exist on that road?
Discuss it? Not so much. Did I research it myself? Yes.
You also said you went and, before you closed the road down, you spoke to your neighbors, and some of them signed
Yes.
on this road. Did anybody disapprove?
The neighbors that touched the property, the ones that needed to sign in order for it to be legal, all agreed, they all signed.
That's not what I asked. I said, did anybody who you spoke to disapprove of you closing the road?
Did anyone I asked disapprove of me closing the road?
Anybody disapprove of you putting a road closure
That I asked.
that you spoke with?
that I spoke to. I'm just trying to be clear. Prior to putting it up, no.
So everybody that you know, as you spoke to, was go ahead and close the road.
That I spoke to, I just want to be clear, that I spoke to,
Okay.
no, they didn't object.
All right. And that's it for me.
I have a couple questions. Some of them are for Mr. Epps, but some of them are also about current ordinances. So just let me know what I can ask now and then what might need to be directed later in terms of testimony. But,
Yeah, so just generally, I think right now, focus on Mr. Epps. Later, once everyone's presented them, what they have to say, and we discuss, or you all discuss amongst yourselves, if there's further clarification that's needed, you can direct that at folks that may have that information.
Okay, thanks. So do you have, and I think you might have asked this, but I just want to clarify, do you, as a property owner, have a right-of-way easement on all of the other roads in your neighborhood?
A right-of-way easement? No.
You don't, so you're not, so in your neighborhood, if your property is not touching that road, you do not have the right to drive on it?
We do drive on it, but based on the evidence as far as right-of-ways goes, do I have a right-of-way legal?
As a neighbor?
As a neighbor, no.
Oh. I know that you don't have an HOA. Is there a road agreement between your neighbor, like between the neighbors? Like who maintains the roads, or is it just everyone, if there's a part of the road is failing on your particular piece of property, it's your responsibility to fix it?
There's no agreement.
There's no road
And
agreement.
as far as I know, no one has taken it upon themselves to fix the different potholes along any of the roads.
So the road as it is now is the way that it was when it was first constructed? Like no one's made any improvements to it?
Not while I've been there. Not while I've been there. And the hole where the culvert is, it looks original.
Okay. So are you, and I've actually had this same issue personally myself. So your deeded plot does not say anything about giving you an easement to any other right-of-way easement to any other road to leave your property?
Not the plot that existed when I bought.
Interesting, okay.
And I'm basing everything off of what we all saw. That first plot is what I bought off of, and it makes no mention of a right-of-way.
Okay. Then that's not for you then. Sorry, I'm going through my notes, and I don't know if you'll know the answer to some of these, so. Have you ever looked into what it would take to condemn a road that's that damaged that people cannot be driving on it? Instead of like closing it, like condemn it, or like what the procedure is for stopping traffic on something that is too damaged to drive on?
That's why we did the road closure agreement. So the answer is yes. And we did the road closure agreement.
No, I mean, like, have you looked into what the legal, like what you're supposed to do procedurally or legally?
I sought counsel, and counsel.
Hey, Robert, you do not testify about our communications, okay? You can answer the question to the extent it is just, did you do anything, but please don't testify to the substance of our communications.
Yes.
Okay, hold on, I have to think about what the,
While you're thinking about
Yeah,
that,
take it.
if I could ask you a question. So you've been living here 22 years, and the road's progressively getting worse and worse. What's going to happen in the next 22 years?
It'll continue to get worse.
So do we make it a park, or because you're going to have weeds growing through there at some point? I mean, I'm just trying to figure out what the next step is, because we're talking about, there's a lot of different branches that we're reviewing tonight, and one of the big ones is this road is progressively going to get worse and worse over time.
The best way I can answer it is a hopeful answer. If the village wants everyone in Marvin Estates to give up their property rights, then the village, instead of having a conditional acceptance, needs to just fix it, petition everyone to accept it. If that's where the village wants to go with this. But they need to do it to everyone, not just me and the 4 other homeowners.
Oh, no, I completely agree with that. Being consistent is key
Consistent,
for
yes.
the village. Yeah, there's no question about it for its integrity and all that kind of things. Because I just look at it and I know the village has come together in the last 25 years. And they're trying very hard to put good ordinances, and you've, in your term or time on the board, accepted many text amendments to make it better and better and to improve our quality of life. So my big concern is that, yeah, there are some roads out there that may not have been available for the Powell bill funds at the time. And I know you said that you thought that it may have been, what were the words, unethical for you to ask for it. And I wish you had at the time to have it on record to say, hey guys, I'm part of the village here. Yes, I may be on the council, but this needs to be brought in somehow, some forth. And I think that was more of a statement than a question to you. And I'm not trying to minimize the issue here, because it is a serious issue. Because again, for new drivers, I know that there's going to be a roundabout so that people may not have to use Pacer as much as they may have in the past, but even still, in my eyes, it's public road. I mean, how many people drive through our areas, they go down to South Carolina, we can't stop them in any way, shape, or form. And so here, I'm looking at it, this is a public road, and how do we stop people from driving on it is my big concern.
One of the side effects of what we've done, Joe Carr's traffic has lessened. It's my understanding, but I don't know for sure, that Marvin Creek has, their traffic's lessened because that South Carolina traffic is using the roundabouts for what they were designed for. So now that you can't come up Joe Carr and cut through, and keep in mind, I can see Joe Carr from my house and I hear the noise. So for me to say that traffic has diminished, you could do a DOT survey, but it's at least 20% slower, if not more. And the sheriff deputy could probably speak more to that. But I've heard Marvin Creek's traffic has diminished. People are using the main thoroughways now instead of cutting through, which is I think a benefit to everybody. The other thing I would mention is, not everyone understands this. I do, having done the research, having been on council, but once you give it up, you have no say. Union Power has been asking me to take the power lines out of the trees for the last several years. And now that they're bringing it up, Joe Carr, to the Sage development, maybe some of you saw how they just cut all those trees right in the 200-foot buffer. They just hacked them down. That, I believe, is Union Power. I don't know for sure. But if they come down Pacer, because they don't have to ask my permission, that's what Pacer will look like. Now, that's just a fact. It's not a consideration of why I did that. I'm not using that as an excuse. But they have asked me to take the power lines off of Elysian Fields, which I own, which would benefit me, to get rid of that power line. It's ugly. But I've said no. If these roads become public, I don't get to say yes or no. They're just coming. And it's something they want to do. They don't want power lines and trees. So all the power lines that go between the houses from Chestnut to Saddle, they want them out of there. Now, where they would put those without an easement is now in the public right-of-way, and that'll be their right. So it's more than just crumbling asphalt for most of us. And as I look down the road now and I see kids riding their bikes and being able to play in the road where they couldn't before, that too is a benefit. And I realize other residents in the neighborhood are upset that they feel like it was a unilateral decision, and that's what was reported to the news. That's why my horse property got vandalized. It wasn't a unilateral decision. It was 10 years in the making. I resisted it some years. I could have done it. I could have pushed forward sooner, but I just didn't want to deal with the drama. I'm dealing with it now, but we reached a point where something had to be done. And when I saw that others on Saddle were also thinking something, but they were thinking about doing it on Saddle, I thought, I'm the only person that owns both sides. Let's talk about it again. And we talked about it, and that's what we did. I hope I answered your question in there somewhere.
You did. I mean, there's a lot to unpack. There's no.
There's a lot to unpack.
I see both sides very clearly. But did you have
The other thing that's not mentioned is that Chestnut is closed with a fence. It's open another 200, 300 feet. Saddle is closed with a gate. Okay? The fire marshal came out and said that I had to put in a cul-de-sac, which, by the way, wouldn't have changed the fact that the road was closed. He came out, hell-bent on, he had been sent out to make me move the fence. He said 97-foot cul-de-sac. He'll confirm, it's public record, it's in the NOV that he submitted. Well, if he makes me do that, Chestnut and Saddle need to do that. He has to enforce it across the board. Will he? I don't think so. But Saddle has a gate, and I don't believe a notice of violation's ever been issued to them. I believe the fence policy, if I tracked it back after I heard about it in the new MDO, I think it actually tracks back. So to say it doesn't apply because of the new MDO, I don't think that's true, but I don't know for sure. So 2 roads have already set a precedent, and one of them was marked with a private sign. It mysteriously disappeared once this became a conflict, but for the last 10 years or longer, there was a private road sign. Now it's gone, and beyond it was a fence that goes across so that people can't go down there and park. On the plat that you saw, I think the original idea was that it would connect to the Marvin Creek property, but that didn't happen. That's where the walking paths are. So those homeowners, and I don't think anyone complained, put a gate across, stopped everything. They did the same thing on Saddle. The road condition down there is as bad, if not worse, than mine. But again, what we did over on Pacer is now one of 3. It's not solo, and it wasn't a unilateral decision by me.
So there are multiple gates up on these private roads.
There is, and there is. I think I have photos. I submitted them to the court when I had to go to the Union County Court. I've also seen discussion, and as I did research on what's been going on, I've had my head in the sand for the last several years on purpose. Now that I've had to poke it back out, I have seen that there were communications about resisting a walking trail coming up Saddle. And what those folks may not understand is public road means there is no permission to be asked. A private road, they have to ask. The other thing that hasn't been mentioned tonight is for at least the last 10 years, as far as I can remember, Union County Sheriff deputies, anytime we have a speeding problem or any issue, they've said over and over again, we can't ticket, it's a private road. So they won't enforce any speed laws. And I think the letter that the folks from Saddle sent me alluded to that, if I remember correctly, that they can't do anything because they're private roads. What they have done is no trespass people, which they can do per their supervisors because it's private roads. But when it came time, when someone objected, not just the interior residents of Marvin Estates, but there's outside forces at hand to get this fence taken down. Now it went from private to public. It's It's been private since I've been there. Now it's public, all of a sudden, at least in the language. And that's, I don't think people's property rights should be juggled that way.
I believe that is a civil issue. We've had that same issue in our neighborhood as well. So I believe you'll have to take that up with the Register of Deeds, and then there's a whole other process for that. But
The sheriff's department also agreed it was a civil issue. The Village of Marvin getting involved, it was my understanding they wouldn't, but they ended up doing it.
you should check with your attorney.
Thank you.
I don't have any additional questions for you, but I do have questions about ordinance questions.
And will those be directed at Mr. Nestor? Or do you know who those questions will be directed at?
Yes, Mr. Nestor could definitely answer.
Let's
Yes.
hold off then. Let's let Mr. Bo finish his case in chief. We'll determine if there's anyone else that has standing to speak tonight. And then once you all are discussing the decision, I think that's the appropriate time to ask those questions. Anyone else have questions for Mr. Epps? All right. And Chaplain, you'll get a chance as well. And the follow-up here is just going to be on newly presented information. So we want to avoid, either one of you can go first, but we want to avoid retreading the same ground.
Do you have questions?
No further questions for him.
I don't have anything further either. And I don't have any further witnesses. Robert, you can come sit down.
You said no further witnesses, Bo.
I do have a question. Do these all stay here?
Yes, leave the exhibits there, please.
So is there anyone else here who contends that they have standing pursuant to statute 160D-1402C to make a statement here tonight? Following persons have standing to file a petition, these are the following folks that have standing. A person possessing any of the following criteria: an ownership interest in the property that is the subject of the decision being appealed, a leasehold interest in the property that is the subject of the decision being appealed, or an interest created by easement, restriction, or covenant in the property that is the subject of the decision being appealed. B, an option or contract to purchase the property that is the subject of the decision being appealed. C, an applicant before the decision-making board whose decision is being appealed. Number 2, any other person who will suffer special damages as the result of the decision being appealed. For those of you who are not aware what special damages are, those are actual damages, lost wages, personal injury, not general damages like pain and suffering or something like that. Number 3, an incorporated or unincorporated association to which owners or lessees of property in a designated area belong by virtue of their owning or leasing property in that area, or an association otherwise organized to protect and foster the interest of the particular neighborhood or local area, so long as at least one of the members of the association would have standing as an individual to challenge the decision being appealed, and the association was not created in response to the particular development or issue that is the subject of appeal. And finally, a local government whose decision-making board has made a decision that the governing board believes improperly grants a variance from or is otherwise inconsistent with the proper interpretation of a development regulation adopted by the governing board. So I know that was a mouthful. I'll ask again if there's anyone here that believes they have standing. All right. So one of you all can come up and we'll try and figure out whether or not standing does in fact exist.
I just want to speak facts of the matter.
Well, and
Stephen.
quickly, I'm sorry.
Stephen Simonelli.
And can you sign in
Yeah.
there? And I think what we have to do now is, can you explain the basis for your standing. And I'm going to ask if either party has objection to you testifying.
And then he has to be sworn.
I'm sorry. Yes, you will have to be sworn. if
I'm
you're-
Stephen Simonelli. I live at 9687 Saddle Avenue. And I believe I'm one of those things.
Okay.
And anyway, the fact,
Well, hold up. Are there any objections to, I'm sorry, what was your last name, sir?
Simonelli.
Simonelli, it's Mr. Simonelli testifying. Okay, and you have to be sworn in first, sir, since you're going to be testifying. Chaplain, you have any objection?
Do you solemnly swear or affirm that the testimony you're about to give during this hearing is the truth, the whole truth, and nothing but the truth?
The facts of the matter is, I actually agree with some of the things that Mr. Epps is trying to do. Close the neighborhood, keep it quiet, keep it quaint. And we spoke in length for a couple of years. I'm in the neighborhood 11 years. I spoke about gating the 3 sections. So let's say he's doing it now. So let's say you. All right. So here's the facts. Let's say you and you are the corner of Saddle Avenue. You and you are the corner of Chestnut. He owns the corner of Pacer. He's going through this to gate to close it off. So now let's say you want to do the same thing as him, and you want to do the same thing as him. Now it becomes which access point is actually the easement. Yes. So there's 3 access points, Saddle, Chestnut, and Pacer. If he does his closing, and you do your closing, and you do your closing, what access point is the easement for all of us to get into our houses? So at that point, they're all easements to get in and out. And if and you're right, we own the road to the middle of the street to where the iron is. So you can sit here and say that I own the road to the middle of the street, but I don't want to fix the culvert that's under my property. We're all responsible for our fronts of our streets. So we have gotten together as a community, and we are creating a maintenance fund for the neighborhood to redo the streets. We already got prices on repaving the entire neighborhood. We got prices on gating the entire neighborhood. And Mr. Epps is right. Once you guys do that roundabout over at Joe Kerr and Marvin, there's going to be 10,000 cars coming through that neighborhood. So what we're trying to do, and I spoke to Robert about this before any of this went even this far, about getting together with the neighbors and let's gate the community. And that really solves all the problem, because really what he's doing, you and you can do. And if he gets approved to do it, that means you guys could do it and you guys could do it. Now who has the access, which street is actually the easement to the rest of the neighbors' houses? So at that point, you got to keep all 3 access points open until the community comes together and either gates the entire community. I agree with Robert with keeping the neighborhood private. I don't want Marvin to come and take over, because in my opinion, you guys are killing the village of Marvin, letting commercial property come in, letting people build houses on less than an acre of property. That's just my opinion. You guys are destroying Marvin. Second of all, if we gate the community and we have a maintenance fund that we all contribute to, we get the culvert fixed. Everybody in the neighborhood pays to get the culvert fixed, not just Robert, because we're all going to use that easement. We're all going to use that access point, so we're all going to pay for it to get repaired. We're all going to get our streets redone, and the neighborhood stays private. The power companies stay out, the Marvin Loop stays out, and that's it. It's simple. All of this is like, I don't understand. I come from the streets. I don't understand none of this, what you guys are saying. I'm just speaking facts. And the facts are there's 3 access points to the neighborhood. If one guy has the right to do it, the other 2 guys have the right to do it. So at that point, in my eyes, all 3 access points stay open, and we gate the neighborhood. And then we create a maintenance fund, and we fix the roads, because all the roads look like that, what was up there. I'm at the corner, and the two gates the gate that's on Saddle is all the way down at the dead end. And that was put there because people were going down and dumping. Contractors were going down and dumping. Those are dead-end streets. Saddle's a dead end, and Chestnut's a dead end. So those two gates are irrelevant to what Robert has done on Pacer. But in my eyes, either all three access points stay open, or, like I said, if he does it, you have the right to do it, and you have the right to do it. So we either get together as a community and gate the community to stop the traffic that's about to come from the roundabout, or it just stays the way it is, and then we're going to have tens of thousands of cars coming through on our neighborhood. That's just my opinion. It's simple.
Any questions, Bo, for Mr. Simonelli? Chaplain, any questions? Okay. Anyone else believe that they have standing? Yes, sir. What is the, first state your name, please?
My name is Dan Weber. I live at 9705 Saddle Avenue.
Can you sign it on that sheet?
I would be glad to.
And Bo and Chaplain, same question as before. Either of you have objection to this gentleman speaking?
No objection.
What's the basis for standing?
Sir, what's the basis for your standing?
Number 3 on your list, I believe. I live in the community, and I have the right from an easement perspective to have a conversation about this because the Marvin Board of Adjustments is here tonight to discuss the right-of-way and easement of Pacer, which affects me as a homeowner.
So I think you're referencing you're saying you have an ownership interest in the property at issue here tonight? Is that what you're saying?
I live in the neighborhood. The
Okay.
same reason Mr. Simonelli was able to speak is the reason I'm able to speak. I'm requesting access to speak.
Objection, Bo?
Yeah, objected. He doesn't understand.
The,
I'm sorry, but the audience, you can't speak out loud.
and so it's up to the board now, if you believe that this gentleman has standing based on that statute, and if you do not believe he has standing, you still have an opportunity, if you would like to hear him and he has relevant information that's competent and relevant and is not repetitive, you can still hear what he has to say if you so choose. But if he does not have if you reach the conclusion he doesn't have standing and you'd still like to hear him, then there's going to be a time limit on what he's allowed to present, or how long he's allowed to present.
Where's your property, sir?
9705 Saddle Avenue.
You're on Saddle. And are you aware of any easement or right-of-way you were granted in your deed to Pacer, to use Pacer?
Yes, ma'am.
So you have that
I
right-of-way?
believe we all have easement across each other's property, as you've alluded to. I walk across Pacer, I drive on Pacer, even though Robert's section of Pacer is closed. Pacer does not end at Robert and that property. So I believe that I have the right to have a conversation about the easement rights on Pacer and submit to you evidence that the neighborhood is.
And hold on quickly, are you all taking the position that he is standing to speak tonight, or are you going to allow him to present?
I mean, if he says he has an easement.
And I just want to make sure we're clear, because if that's the case, he's got to get sworn in. So I just want to make sure he gets sworn in before he starts to present any evidence. Yep.
Do you solemnly swear or there you go. Do you solemnly swear or affirm the testimony you're about to give during this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. So first of all, good evening and thank you for the time and the opportunity to allow us to speak as a neighborhood on this matter. I would like to address a couple of things that were brought up tonight, and then I'm going to read a petition from the neighborhood. First, I believe Steve alluded to it, but the statements made that Saddle and Chestnut roads that are blocked at the end are the same, and it sets a precedence for the blockage of Pacer, do not apply. And I will say that for 3 reasons. 1, those are dead-end roads with no through traffic. 2, you can walk around those gates without having to climb over them for foot traffic. 3, there are no driveways past those gates. So everybody in the neighborhood has access to the end of the road. And 4, and most importantly, I'm not able to speak on the fire marshal's behalf, but I will speak on the information that was provided to me when I asked this question. That is, those roads are grandfathered on the plot maps, and the turnaround that he is saying would apply to Mr. Epps's blockade, those two things are not equal. Those two roads are grandfathered. Robert has created a dead end, 2 dead ends actually, a dead end going towards Joe Kerr and a dead end going away from Joe Kerr. So I just want to clarify that those 2 roads do not set precedents for the blockage of Pacer Road. Thank you. The next thing I'd like to state is the entire neighborhood was not asked about this closure. I believe, and I believe that you've seen on the plot maps, that we have easement across each other's property. I walk across Ben Buchanan's easement. I drive across the Williamson's easement. I drive across the Shaw's easement. I drive across Bill Sturry's easement. I drive across, well, who else do I drive across? Probably their easement. I drive across his easement on Pacer. The point is, I drive, I walk, I ride my bike, I run across each other's easements. We all have easement across each other's property. Now, Robert is correct in the fact that we all have a responsibility to take care of that road, okay? But I would also state that you can't have it both ways. If it's a private road, as he seems to say it is, then its responsibility is to fix the culvert. You can't put a fence across the private road because you want to not have the culvert be damaged any further. So, having said that, I just wanted to clarify that it is our interpretation as a community and as illustrated here tonight that we have easement across each other's property. Now I would like to read to the Board of Adjustments a petition. To the honorable members of the Town of Marvin Board of Adjustments, we, the undersigned residents of Marvin Estates, respectfully and urgently petition the Town of Marvin to uphold and enforce our neighborhood's established right-of-way on Pacer Lane, as well as the Marvin Development Ordinance, and to require Mr. Epps to remove the blockade he has constructed across this vital access road. This obstruction is not only a deep inconvenience, it is a serious safety hazard. Emergency services, fire, EMS, police must now take a longer alternative route, delaying response times and putting lives at risk. Families, seniors, and children who rely on safe and reliable access to and from their homes are now burdened and endangered by this unilateral and unlawful action. For decades, every resident of Marvin Estates has enjoyed uninterrupted access via Pacer Lane. This easement is clearly documented on the neighborhood plot maps and has been historically honored by the community and local governance. We ask the board formally recognize and affirm the neighborhood's right-of-way on Pacer Lane. Order the immediate removal of the blockade erected by Mr. Epps. Take all appropriate actions to ensure safe, legal, and consistent access to our homes for both residents and emergency services. This issue is not just about one road. It's about protecting the rights, safety, and unity of our entire community. We urge you act with fairness, resolve, and urgency. It is signed by 37 members of the neighborhood, which represents 21 of the homes. So spouses, my son who's sitting here has signed one, and other members of the community. There are 37 signatures. I would also like to point out, Mr. Epps alluded to having conversations and discussions with some individuals that signed that, and I will not speak on one of those individuals' behalf because he's sitting here, but he has signed this because what was the discussion around closing Pacer Lane was misrepresented. I think Steve alluded to it. We all agree cutting down on through traffic, safety of the neighborhood is important. But I don't believe the discussion around closing Pacer Lane was communicated appropriately. The last thing I would say is there's been reference to 500 cars on Pacer Lane. My wife, who's listening at home, is probably 20 of those in one day. Ben Buchanan's wife, our neighbor, is probably another 20. The point I'm trying to make is, yes, he has shut down traffic on Pacer Lane, but the overwhelming majority of that is because the neighbors cannot use Pacer Lane. And to the point in the email that you brought up, every time I come home, I have to go up to Marvin Road and take a dangerous left turn that would otherwise be an easy access left turn into Pacer Lane. So again, Board of Adjustments, thank you for your time. Thank you for all that you do for our community. And I'd like you to consider the fair and quick removal of the fence across Pacer Lane. Thank you.
Are you planning on
And
submitting
can I submit
that?
this as evidence? Am I allowed to submit this as
No
evidence?
objection.
You can vote if, did you say you object, or you said you didn't object?
I do not.
Vote if you want to allow it. Either one of you, or Bo or Chaplain, are welcome to ask any cross-examination questions about what Mr. Weber has said or about that document that he intends to enter into evidence. Questions, Bo or Chaplain?
Yeah, I've got questions. Did they overrule my objection?
Do you all want to rule on his request to enter into evidence?
Is this a formal vote? Does it need to be a motion with formal ayes?
It doesn't need to be formal. We just need the board to.
It sounds like the majority are willing to allow it.
Okay.
Shall I leave this with someone?
Yeah, bring it over here. Thank you.
Please grab a microphone.
You testified that your deed referenced an easement across Pacer Lane?
No, it does not reference an easement across Pacer Lane. It referenced right-of-way on Saddle Avenue, which all of the neighbors have right-of-way across each other's property.
Okay, but I'm asking you, sir, you testified that your deed provided you with an easement that gave you standing to testify here today, correct?
No, I said I live
That
on
you didn't
Saddle.
testify to that?
What I said was, I believe I have the right to testify because we all have easement across each other's property.
Who's each other?
All of the neighbors in the...
Including Mr.
all-
Epps?
Just quickly, again, these are the folks talking right now. If you all have something to say, you can, but it just gets confusing if too many
Yeah.
people talk at once, all right?
Including Mr. Epps?
I believe I have the right to drive across Mr. Epps's easement.
You're saying you believe, but earlier you said you had an easement to do that. Where does that easement come from,
It
sir?
says right there on the plot maps that I have a right-of-way on Saddle Avenue.
What plot maps?
Didn't we just review plot maps that showed right-of-way?
That showed Mr. Epps's property and lots on Pacer, but they didn't show any lots on Saddle, sir. So I'm asking you, where does your easement come from?
I'm sorry, I'm not truly understanding your question.
I'm not understanding your testimony. So I renew my motion. He doesn't have standing. He has not established that he has an easement. He's saying he's got some right. He doesn't know where it comes from. He doesn't have standing to
Can I answer
testify.
that question? My rights are based on, even if the plot maps do not apply, I have prescriptive easement because Pacer Avenue has been, Pacer Road, excuse me.
Pacer Lane.
Has been an easement for the neighborhood of Marvin for 55 years.
And how long have you lived on Saddle Avenue?
3 years.
Okay. And so,
But there's members in the here tonight.
right, sir, and I understand you think that you have some right to speak for them, but
I don't have
I'm
right
just asking you questions. Please answer my questions, okay? So my question is, where does your easement come from? What document, sir, gives you an easement over Mr. Epps's property?
I have easement across Mr. Epps's property because it is a right-of-way in and out of my neighborhood.
Okay, but from what document, sir, was my question? What document gives you that?
Currently, there was, Mr. Nestor submitted several documents that state a public easement. You have contested them, but they are still registered with the
Correct.
Register of Deeds.
They say public right-of-way over half of Pacer Lane, which is not the half A that he owns, it's the half his company owns.
I'm
And
not going to argue with you over the documents.
Well, but you're interrupting my questioning to make that statement, so I don't.
Then please feel free to go ahead.
Okay, thank you. Mr. Weber, is this person in this video you? Is that you, sir?
No, sir.
That's not you walking over Mr. Epps's property
No, sir.
in what appears to be a plated vest?
No, sir.
It sure looks like you.
Never had a plated vest on, sir.
It sure looks like, it looks a lot like you.
Bo, what's the importance of this?
Kicking
If
that
he's
chair.
walking
Not
down the
me.
street?
It's not me.
Well,
Hold on. It is not me.
it's not you. Do you know who it is?
100% not me.
Who is it?
I can't determine by, you won't hold still long enough? I don't know who it is, but it isn't me.
That's not you?
100% it's not me.
All right.
Why don't you submit that?
You said it wasn't-
Guys, I understand people have things to say, but it's muffling the record. The point here is to get a clear record, so we need to have one person talking at a time, okay?
Because that's defamation, because that is not me.
Okay. Sir, you've thrown a lot of legal terms around here, so just let me understand. Are you a lawyer?
No, sir.
You ever go to law school?
No, sir.
Okay. Do you have any special training or knowledge of the law?
I'm a citizen of the United States of America. I have the right to speak. They've given me the right to speak.
Okay.
So I
My
have the
question
right-
was, do you have any specialized training in the law? Was my question.
No.
Okay.
But I do know what defamation is, I do know what easement rights are, and I do know what we're talking about tonight is on the plot maps. And even if the plot maps don't meet the threshold needed for this board to rule in the favor of we have easement, there's prescriptive easement that was not discussed tonight. Prescriptive easement is a defensible law term that would allow us to have the right to pass over Pacer because it's been established for greater than 10 years. So is there anything else we'd like to talk about from a legal perspective?
Sir, in order to get to Marvin Road, do you have to go over Pacer Lane?
To get to Marvin Road, do I have to cross Pacer Lane?
Do you have to go over Mr. Epps's, where the fence is on Pacer Lane to get to Marvin Road?
No, I have to go over Pacer Lane, though.
And from Marvin Road, can you
So let me
get?
answer your question.
Sir, I'm sorry, just let me finish my question.
Let me answer your question. Yes, I have to cross over Pacer Lane to get to Marvin Road.
Okay, so you have to, in order to get from your property on Saddle Ave to
Cross Pacer
Marvin
Lane?
Road, you have to go across where the fence and gate is
No, that's not
located.
what you asked me.
That's what I'm asking you right now, sir.
You asked me if I have to cross over Pacer
Well,
Lane. Yes.
we'll answer my next question, which is, do you have to go past the part of Pacer Lane where the fence and gate is? Do you have to do that?
To access Marvin Road, I do not have to cross past Robert's house. But to access Joe Kerr, the only access point to Joe Kerr out of our neighborhood is across Pacer Lane in front of Robert's house, which again has been accessible for the better part of 50 years.
The plot maps that we saw today, you were in here while we were looking at them.
Yes, sir.
Do any of them depict your property?
No, sir.
Those are my questions.
Have any questions?
Anything, Chaplain?
Do you believe that Pacer, how long did you state that Pacer Lane had been used by the public?
Well, I think the plots were originated in 1970. Is that correct? The neighborhood was 1970?
Okay.
75? So that's 51 years, right?
And you believe that from your knowledge and speaking with others, you believe it's been used by the public during that time, since it was open?
Yes, sir.
Thank you.
You have any questions?
I just want to clarify that, because you said by the public, but you're specifically referring to that your community has an easement right-of-way to use Pacer Lane.
Yes,
No,
I
you're
believe
not
so.
necessarily speaking about the fact that you believe that the public has the right-of-way. It is the community that you are arguing has a right-of-way easement to Pacer, Chestnut, Saddle.
Yes, and I would also say that the day that Mr. Epps was putting the fence up, I went down to speak with him and the gentleman standing right here, and I said repeatedly, your intentions are not misplaced. Your actions have created a problem. Cut through traffic, we all agree. The neighborhood has gotten together, as Steve has shared. We would like to work together to put speed bumps up. Some talk gate. I don't think we'll ever get to a gate, to be honest with you, because I think that's a lot. But we could put speed bumps up, we could put signs up, and we can do some things. But again, throwing around 500 cars a day, he might see 500 cars a day. But 400 of them are neighborhood cars. And I have access to that road just like he has access to the road in front of my house. I would also add that to the middle of the road, we all own. To your point earlier, I can't build, like if I went and asked if I could build a shed at the end of my driveway that would go halfway into the road, I wouldn't be allowed to do that. You would not approve that, would you?
Don't answer that.
No, he would not.
The-
And neither would we.
The point I'm trying to make is the fact that we own to the middle of a road does not give us right to obstruct the passage of that road. That's all that I'm saying. So again, thank you for your time. I appreciate it.
All right.
I'm sorry, you actually cannot clap. I apologize, but you're not allowed to clap either. You got to stay silent as church mice.
Is there anyone else that contends to have standing? Yes, sir. And before you get into whatever your testimony is, what do you contend the basis of your standing is?
This is basically, and I will ask the board to either accept my statement or not. I would like to, and I speak with Robert. I think he's a great young community member. We need to bridge the gap here, and we have, as a community, been taking steps to come together as a community.
Well, and sir, before you get into that, because if you're going to testify, you have to be sworn in. So we have to follow the process here, okay? So my first question for you is the basis of your standing.
Right. Well, it's similar to my predecessors with the easement, but it's also a safety issue as well. So safety in the community. That's one of so whether or not my statement's going to refer to that, it's.
Do you live in the community?
I live in Saddle Avenue, yes.
Okay.
I'm neighbors with Simonelli
And your basis for standing is what we heard from the other two
Yes.
gentlemen. Bo?
Do you have anything new to add, sir?
I do, yeah.
Okay.
And just for the record, do you have an objection to this? Chaplain, do you have an objection to this?
I do not. I also think the board has the discretion under 160D-406, as you noted earlier, even if he doesn't have standing, if it's relevant, they can choose to allow, which you already noted.
And that's the question for the board now, is if you would like to hear from this gentleman, and I'll remind anyone that makes a statement, we've heard a lot tonight. If you make statements, I think it should be something new. We don't want to retread the same ground. So it's up to the board as to whether or not they want to hear this
If he has
gentleman.
the same standing as the first two testimonies, then there's no reason why he shouldn't say his piece, just please no repetition.
Yeah, please sign in, and then we're gonna swear you in. And sir, could you please state your name as well?
My name is Dave Waldman. I've lived on 9691 Saddle Avenue for about a little over, almost 2 years. So I had the opportunity to meet Robert as one or two other members that are here today. And I happen to think Robert's a great guy. He's a respected developer in the community, and like Steve said, we definitely understand and appreciate his concerns about safety in the neighborhood. You know, we're all neighbors in this community, and we all want to work together. And despite the fact that we have not come together to have a mutual meeting, because things are a little bit contentious. You have a lot of community members that are upset. There's been a lack of information flowing to and from, and whether or not we agree or disagree, I'm here to state that we're going to be in this community for a long time. So I hope at the end of the day, whatever and however this board rules, that it would be an opportunity to come together as a community and work together to solve problems, including one of the reasons why, or several reasons why, Mr. Epps boarded the fence. We all want safety. We want safety for our kids. We want a peaceful community as well. So I'm here to send that olive branch to Robert at the end of the day, because we could go back and litigate this in the courts from here to Timbuktu. We all know how the litigation process goes, and I don't think anybody's going to win at the end of the day. But we can come together to collectively have a solution. Several community members, Steve and others here, we sat down, we got quotes for gates and fixing the roads collectively as a community. So the opportunity to come together with the rest of the community, the majority who does not agree with the fence and whose statements were signed and submitted, let's work on solving this. And at the end of the day, I feel a lot of confidence that everyone is going to be happy with the end result. And that's all I have to say. Thank you.
Questions, Chaplain or Bo? Anyone else contend to have standing? You're welcome to come up and present why you believe you have standing, and then like we've done with the other folks, the board will decide.
I mean, safety, and I believe I have easement rights.
Microphone, sorry.
Safety is a concern, and I believe I have easement rights.
And do you live in the,
I live at 9824 Saddle,
okay.
on the
She's
corner
one
of
to
Saddle
20
and
drives
Marvin.
a day.
I'm sorry. Oh, okay.
20, yeah.
Bo, same objection? Yes. Chaplain, no objection. All right, and again, it's up to the board. And same rules as before, right? We're going to try not to repeat things.
I have two quick things.
Sign it on the sheet, and I got to swear you in.
Yes.
Do you swear or affirm that the testimony you're about to give during this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Yes. I just have two quick points. One, our neighborhood does have covenants. Mr. Epps. Oh, sorry, Katie Shaw. Our neighborhood does have covenants. Mr. Epps has signed them. There's multiple iterations of them if you go back through the Union County records for years and years. The last time they were changed was early 2000s maybe. They do make mention of easements for utilities and that type of thing in the neighborhood. They make mention of you should make sure things aren't obstructing roads. I'm sure Mr. Bowe's going to ask, there's no specific mention of fences across roads, but we do have covenants that kind of unite our neighborhood. Second thing is I have a daughter who turned 16 in December. She has been taking that left from Joe Kerr onto Marvin ever since this gate went up, and it terrifies me. There are several other younger kids in the neighborhood. I have a 13-year-old. There's other kids that are getting right to that age that they're going to be turning 16. And I think it's a true safety, it's a safety risk to all of us, but really a true safety risk to a new driver. And that's what I got.
Thank you.
Questions? Bo? Chaplain? All right, thank you. Does anyone
Actually,
else?
I'm sorry, I do have one question for her. As a woman and as a mother of a daughter, if the gate were to stand unlocked, would you or your daughter feel comfortable at night getting out of your car and opening that gate in order to ingress, egress?
I would feel comfortable. I wouldn't be thrilled about my daughter doing it, but I mean, I feel like we live in Marvin. It's a generally very, very safe area. But you prefer for your kid not to get out of their car at night.
All right, thank you.
What she just spoke on about being unlocked.
Well, sir, unfortunately,
It's unaccessible.
unfortunately, we can't just open this up to people saying things, okay? Everyone's had their chance, right? And that's the chance you get. Is there anyone further that contends to have standing? All right, and Bo, do you have any further testimony? Sir? Okay. Same question as before.
Yeah.
Basis.
721 Saddle Avenue.
Okay, and is your basis for standing the same as the other folks have? I'm sorry?
My driveway's right in front of Pacer at the other end,
Okay.
so that's why I have standing.
Objection, Bo? Chaplain? And does the board want to hear this gentleman?
Yes.
Okay.
Go ahead and sign in.
And please state your name once you sign in, sir.
Do you solemnly swear or affirm the testimony you're about to give during this hearing is the truth, the whole truth, and nothing but the truth, so help you God?
The blood of Jesus Christ. All right, so 9721
And
Saddle.
I'm sorry, what's your name, sir? Just
My
so-
name's Barnabas.
Okay.
Sir, say your full name and your address.
9721 Saddle Avenue, Barnabas Williamson. All right, so we've been in 9721 Saddle Avenue for 34 years. I have driven on Pacer, up and down Pacer, where his fence is, for 34 years. So I have to go up, make that left, and it's dangerous. I got a big truck. I got a landscaping truck. I got a landscaping business. So I have older parents that don't need to be taking a left on Marvin and Joe Carr, when they can just come up Pacer. And the street, when he was mentioning the street, how it needs to be fixed. For 34 years, it's been the same. So I don't understand the new aeonces of the street being undrivable. And the other thing, because of my background of what I do for a living, the vegetation on his side of the street, on Robert's side of the street, is not taken care of. So you can't have water, coming down the road like it's supposed to if you're not maintaining your property on those edges. And that's why the street crumbles on any street, with what we're talking about with safety and culverts and stuff of that nature. I clean a lot of culverts out, and so forth. But what my point is the fact that the access point on Joe Carr and Pacer is just without that access point, it's just so dangerous. And everybody here, Marvin, everybody knows what we're talking about. I hope you guys put a roundabout. I've seen so many accidents on that street. I've seen a car up on the telephone pole. You saw that too. So, hopefully you guys can, do a roundabout, because that would solve a lot of problems. And I don't know what type of traffic we're talking about, because if you got roundabouts, it's flowing, and it flows out. It's not flowing in our neighborhood. The only reason why they're coming in the neighborhood is because there's no roundabout right there. Just like you guys, when you guys finished this one up here, that was wonderful. So it took 34 years. A lot of people died because of these roundabouts have not been taken care of or established. So that's all I was going to say. Is that road is a thorough through, and when you have to go to a dangerous part of another street to take a left or a right, liability has to happen with somebody that blocks the road or puts a fence up. That person should be liable for any accidents or anything of that nature. That's common sense. It's just common sense. That's it. Any questions?
No. Bo, do you have any evidence that you would like to put on in rebuttal to what you've heard since your case in chief? Chaplain?
No, I believe we were both going to do like little brief closings at the end, but I don't have any evidence through testimony of others.
Okay. Well, if we're at that stage then I think it's, if you all would like to present your closings, and then after that occurs, what's typically done is the chairperson or a designee will summarize the evidence that's been presented. I'm happy to do that if you'd like me to. I'm going to distill it down quite a bit, and then each party will have an opportunity to object or clarify if I've misstated or mischaracterized any of the evidence that's been presented today.
I still have questions that have not been answered. Does that happen after closing?
So after I state the evidence as I understand it and we hear any objections, then this will be shut off to public discussion, and the board will discuss their decisions. And if a part of that discussion you have questions or you seek clarification, you can ask the appropriate party for those questions or that clarification.
Thank you.
I'll keep it brief and try to summarize. The village planner testified that MDO 1213-2 applies whether you have a private or a public easement, but we don't really have to get into that because I think it's clearly public. You had 3 recorded subdivision plats or plats that had dedication language, and you've also got implied dedication. Implied dedication under North Carolina law occurs if you've had 20 years of continuous use by the public. We had testimony that these streets were opened in the 70s, and then we recently had testimony of a neighbor that said he's used it for 34 years, so you've got implied dedication for a public road. The appellate testified that he didn't go through any of the formal closure procedures under NCGS 168-299, but mainly there's no dispute that there's a fence or barrier coming into this road. It's placed there. You saw the pictures. It's right over and across Pacer Lane. There's no dispute that there is a lack of approval. There's no dispute that it requires an approval. There's no dispute that there wasn't even a permit application. There's a clear violation of the MDO that was set forth in the NOV, and we request that you uphold the rulings and the findings in the NOV.
Okay, so I'm also going to try to be brief. There are essentially 3 things going on here, and before I get to the 3 things, as always, the main issue that you're being asked to treat with today is the relationship between the Marvin Development Ordinance, that is the public interest in the development and use of land within the village of Marvin, and the private interest of landowners to make free use of their land consistent with their constitutional rights and liberties, right? And always that's the question before you, and it frequently poses difficult questions, okay? But there are 3 things going on here that we have to resolve. The first question is, does the ordinance that they have cited in their notice of violation even apply? Okay, does it even apply to this particular situation? Now, you've heard a lot of testimony today from people who have concerns. They're right to have concerns. Everyone should pay attention to what is happening in their town, all right? But the village noticed a violation for a very specific thing, and that specific thing was that Mr. Epps and his wife and his company supposedly built a fence over an easement within the meaning of that particular section of the ordinance. All right. So the first question is, what does easement mean within that particular section of the ordinance? And if you look at the language of 2.13G, there is a qualifier at the end of the list of easements, and there's this long-standing rule of interpretation that you apply to things like local ordinances. And the long-standing rule is that that end qualifier applies to everything else in the list, okay? In other words, if the last thing in the sentence says any other public easement, which is what it says here, that phrase other public easement suggests that the other easements listed are also public easements, okay? Otherwise, you wouldn't have to say any other public easement. You just say any easement, right? It'd be much easier to write that. So, in our view, the correct interpretation of the ordinance is that the Village of Marvin is concerned with the construction of barriers over public easements, public rights of access, utility and drainage easements. And that makes sense because we don't really want our local municipalities butting into what is in actuality a private property dispute between private property owners. That could go really sideways really fast, because then you have personalities and who do you like better and who do you not like so much that gets involved. Your role as a Board of Adjustment is to ensure that you limit your authority and jurisdiction to deal with what are actually public issues, and that's why the ordinance only addresses public easements. You don't have a public easement here, okay? And the reason you don't have a public easement here, there are legal reasons and factual reasons, but the most basic reason is that the only evidence that's competent on this question in front of you, okay, you've had lots of people come up here and say, we have an easement, but no one has actually shown you a document, okay, that shows their land that they bought and that says that they have any easement or right-of-way over someone else's land depicted on the document. The only documents that the village has brought to you, and candidly, the only documents the village ever provided me in response to my public records request for all documents supporting their theory of this violation, are the plots that you've seen. And the plots that you've seen only show the stretch of Pacer Lane between Joe Carr and Chestnut, and they are only referenced in deeds where Mr. Epps and his businesses acquired property. So the only thing that's been proven to you today by their evidence is that Mr. Epps and his company and his wife have an easement over Pacer Lane. That's all that's been proven to you today. There is no competent evidence in front of you that anyone else has any such easement or right-of-way. There was some mention of an implied dedication. There is no North Carolina case, no controlling North Carolina case that recognizes the existence of any such right-of-way based on an implied dedication. The law in the state of North Carolina is that to have a dedication, you must have a dedication and an acceptance. A dedication and an acceptance. And you have no evidence in front of you that there has ever been any acceptance. So you don't have a public easement. Now, next question. That was question one. Next question is, do you have a private easement? Okay, and the reason that's a question is because according to their interpretation, again, I think it's wrong, but according to their interpretation of the ordinance reaches private easements. So let's ask, is there a private easement? And the answer to that could be yes, it could be, okay? Because under North Carolina law, there's a decision called Hobbs, okay? And under Hobbs, when a private property owner buys a lot, piece of land, with reference to a survey or a plot map that shows roads and parks and a subdivision, basically, then that private property owner takes the land and they get some rights. They get the right to use those roads within that subdivision, okay? So could there be a private easement here? Sure, there could be. The problem is you don't have any evidence of one. And the reason you don't have any evidence of one is because the only plot maps that the village put before you today are plot maps, again, where Mr. Epps and his wife and his business bought land with reference to subdivision plots that only show that small stretch of Pacer Lane. They don't show anybody on Saddle. They don't show any land past Chestnut. So the problem with determining that there's a private easement is you just don't have the evidence to do that. And as a quasi-judicial board, your decision has to be based on evidence. It cannot be based on your personal experience coming in here today, well, I've noticed this or I've noticed that. It can't be based on someone's unsupported statements of, well, I've seen these things going back 30. It can't be that. It has to be evidence. And the only evidence that you've been presented from the Register of Deeds, where the land records are, that anybody could have gone to pull in advance of today's proceeding, are those plot maps. And those are just that one stretch of Pacer Lane. So there's not even evidence in front of you that someone other than Robert Epps and his wife and his business have a private easement. And of course, they are perfectly okay with that fence and gate being there. And then the last question is, let's assume that there is a private easement and you agree with the village staff that the ordinance applies to it. Let's assume that for a second. Okay. Nevertheless, the testimony of Mr. Nestor was that the village has approved gates over private easements, that they have reviewed them and they have approved them, right? And the testimony of Mr. Nestor was that things that they would usually consider or take account of would be things like safety issues, fire code issues, right? Turnaround issues. And there are other things that they might take account of, like community support. And we have seen that Mr. Epps had substantial support of the people with the most immediate impact, who are most immediately impacted by that gate. Okay? They signed, they said, yes, let's do it. So he had some community support. But Mr. Epps has not even, at this point, he's not submitted an application that has been reviewed and denied by the village, because after he got the notice of violation, he was told that it wouldn't make any difference. He's over an easement. And that's not the way that the village testified earlier it usually does business. So at the very least, he should be afforded that opportunity, the same opportunity everybody else has to submit an application and say, here you go, here's my reasoning, here's what I've done, here's the impact that it will have on everyone's access. At the very least, he should be permitted to do that. Now, again, I understand the concerns of people who live around there. I get those concerns, and I don't envy any of your job. It's a tough job, and you should honestly be thanked by everybody for your time volunteering to do all this and to listen to people's testimony. I know that that it's challenging sometimes, okay? But the reality is these safety concerns that you've heard, while I appreciate them, those are concerns with the village and the public roads. If someone can't turn safely on a road in the village of Marvin, maybe the village of Marvin ought to take that up with itself or DOT, not with Robert Epps. I would appreciate it very much if you would issue a decision today that respects everybody's rights to equal treatment and to the ownership and use of their private property, and that says simply that Mr. Epps and his wife and his business should be allowed to submit their application, that that application should be reviewed fairly by planning, and a ruling should be made. And if at the conclusion of that process we're right here, then the Board of Adjustment can consider it. Or I would appreciate it if you could go ahead and clarify that your ordinance does not create in the Board of Adjustment some duty to resolve private disputes between these private property owners. That if they feel that they have rights that are being violated, they have means to enforce those rights. That's their responsibility to do that. That's all. Thank you.
All right, so what we're going to do now is I'm going to summarize briefly, because we've been here for a while. I'm not going to rehash the whole thing. I'm going to do my best to keep this brief and hit on the high notes. Either party can object or clarify to any of my characterization of what I understood the evidence to be. And when I say any party, I mean Bo, Mr. Epps, Chaplain, Mr. Nestor. After that occurs, the period for public discussion will be shut off, and the board will engage in a discussion on whether or not they're going to uphold or overturn Mr. Nestor's notice of violation. So Mr. Nestor issued a notice of violation to Mr. Epps for a violation of Article 2 for the installation of a fence that went across Pacer Lane. Evidence has been presented by Mr. Nestor that it was his belief that this violated two separate sections of Article 2. Article 2.13-2A, which requires a zoning permit for the installation of fences or walls, and it was his conclusion that such permit was not obtained. There was evidence presented by Mr. Epps that the structure in question does not qualify as a fence or a wall. I did not understand there to be any dispute as to whether or not a zoning permit was obtained. I did not hear or see any evidence that any zoning permit was obtained. The second violation noted by Mr. Nestor was under section 2.13-2G, which states that you cannot erect a fence or a wall over easements. And easements in that section are defined as access easements, utility easements, drainage easements, or any other public easement without explicit approval of the Public Works and Planning Departments. I've not heard any evidence of approval by the Planning Department the Public Works and Planning Departments. The dispute instead is, one, again, whether or not this structure constitutes a fence or a wall, and two, whether Pacer Lane is considered a public easement or an easement at all, as defined under 2.13-2 subsection G. Mr. Epps has argued that that statute requires, based on the reading of the statute, that it only applies to public easements. And because it says or any other public easement, the remaining easements listed there are intended to also mean public easements, and that Pacer Lane is not a public easement. The evidence presented by Mr. Nestor to support his position that it is a public easement were a number of plat maps and deeds which indicate a right-of-way dedicated to the public on those maps. Mr. Epps argued that a dedication requires an offer and an acceptance, and since there's no evidence of such acceptance, there's been no dedication of that road. Furthermore, he maintains that that road is private. There's been testimony from Mr. Epps that that road has always been private for as long as he is aware, and Mr. Nestor confirmed in his testimony that it is a privately maintained road. There's also been evidence entered that both Mr. Nestor and the village manager have called the road a private road in email correspondence. There's also evidence presented that the right-of-way documentation in the plat only went up to the center line of the road. Mr. Nestor testified that he believed that that constituted making the entire road dedicated to public use. Mr. Epps contends that it does not. It only, at best, it comes to half the road. There have been a number of concerns expressed about safety concerns, both in support of erecting the fence. Mr. Epps testified that one of the reasons why the fence was erected was concerns of safety and maintenance of the road generally, as well as concerns for liability. If someone were to get injured or there was an accident of some kind on that road as a result of its deterioration. Other folks also indicated that they had safety concerns about whether or not, if the fence was constructed, it would force folks to take different routes through the neighborhood that create additional safety concerns. There's some discussion or some evidence about this possibly setting a precedent. I took that to be mostly speculative. I've not seen any hard evidence of any precedent being set either way, of a fence being allowed to be there or a fence not being allowed to be there. The village has also testified the village has also presented evidence that that ordinance discussed before, 2.13-2 subsection G, reaches both private and public easements. Mr. Epps has appealed the notice of violation from Mr. Nestor. It is now, before we move this over to the board, it's going to be the board's decision to either uphold or reverse Mr. Nestor's notice of violation. That standard, so the board is aware, is they will reverse the error. They will only reverse Mr. Nestor's decision if they find that he had an error in application or interpretation of the ordinances cited. That was my summation of the evidence. Does either Chaplain or Bo have any objection or anything that they'd like to add to my summation?
No objection.
Okay. We are now going to close this off to public comment. I think the chairperson's technically supposed to do that. And then the board is going to publicly discuss the case without any further input from the public unless specific questions are asked by the board.
All right, so I will officially close it off to the public. Board, I do have some questions that I'd like answered before discussion. Is that okay with everybody? I just asked the board if it was okay if I asked some questions before we deliberated. And I do have a couple of questions for Mr. Nestor. May I ask them? So Hunter, Marvin Estates is one of these neighborhoods that existed before Marvin existed, and we know how documentation is, it's not a subdivision in what we would consider a subdivision moving forward now if they were to apply now. So how would you actually, how is Marvin Estates actually classified by Marvin? Is it a rural subdivision? What classification would you give it?
I'm trying to figure out how to answer that. It's a subdivision that was platted prior to the village being incorporated. They're just all existing lots of record, I guess. I mean, of a common plan, I guess is the best way that I would define it. I mean, yeah.
Would you say it would be the same as like the farms at Meadowlark?
Yeah, it would be very similar to any other subdivision that was platted prior to the village of being incorporated.
So in terms of when we decided to allow gating of private roads, what is the process to gate a private road?
We do not have, that process is outlined in Article 2. I mean, as in, that is what the part of the interpretation is that it is a road that is being used by the residents of that neighborhood subdivision, and therefore they have access, and that would be the process of either obtaining a zoning permit in compliance with the applicable terms in Article 2.13 yeah.
So still, if you wanted to gate a private road, you still have to go through the zoning process in order to do so?
Yes, on top of, depending on, I'm gonna try to say this, depending on how it's platted, on top of where the proposed gate is going, it would also be in consultation with NCDOT. All those streets are typically accessed off of a NCDOT maintained road. They have standards and such that would then apply if a subdivision were to come to be gated.
And if a private road is failing, what is the process for the owner to close or condemn the road?
I would argue, I would fall back on to what the state statute says, and what is it, 160-299, which requires the property owner to submit a application to the council, and the council would have to adopt a resolution, give all property owners that currently use the road, have access to the road, would either have a chance to appeal or have to sign off on that application as well.
And so in order to sign off, in order for the right people to sign off, a real estate attorney would have to do a deeds record search to see who had right-of-way easements and other types of easements to the road.
I don't know if I should, I can't answer that. I mean, I'm not an expert in that field with real estate law.
Got it, okay, got it. All right, I think that's all of the questions that I have. That's all? Already did. Mhm. Anybody else have any questions? All right.
I'm not a fronter, no.
What's that? Okay. So as we discussed, we must do it openly, so if you have a comment or question, please turn your microphone on so that it can be recorded. And I know we've never done this particular part before, so we normally just have an open discussion, so if anyone wants to.
I think there's been a lot of good discussion here tonight, and we've heard from a lot of residents in that division here, and I think there is the potential for them to resolve it. I think that that's probably the best case scenario, regardless of what our ruling will be later on, but I think that all parties want to get involved and want to come to a decision that benefits everybody, and I would hope that you would all do that sooner rather than later.
Regarding Mr. Nestor's ruling, and that's really what we're doing, is do we, I guess, overturn his ruling or uphold it? And there was conversation of, is there an easement, is there not an easement? And Mr. Cottle said that there was nothing but beyond Pacer Lane and Chestnut, but there's plats that we were shown in our package that said right-of-way, 60 feet, not 30 feet, or it says 30 feet each side for a total of 60 feet. To me, right-of-way, and to me, right-of-way and easement is the same thing. So, in that respect, I think that, saying that he cannot block the easement is correct.
Without without applying for a zoning permit.
Yeah,
And even then,
and then, the discussion is, can he block the easement or not?
But as we know, you don't know what you don't know until you actually go through the process, and the process wasn't followed in this particular case.
So what you're saying there is that based up to the point where we are right now, there's been no application for a fence. So that's what we're discussing now, is that he's in.
We're discussing the violations.
Yeah, he's in
And the two violations is not acquiring a zoning permit. And the second one was,
Well, a zoning permit for building the fence, and then
the fence itself.
Would it be helpful for you all if I just recited generally the elements of the two violations?
Sure, go ahead.
So the first violation that was found was under 2.13-2A, and it was that a structure or fence was built without getting a permit first. And the argument from the other side is that the structure built does not constitute a fence or a wall. So I think one question worth discussing is whether or not the structure in question constitutes a fence or wall under Article 2, whether or not a permit was obtained. And that's the first violation, right? The second violation is whether or not the fence or wall was over an easement as defined in Article 2. And I'll read that to you all again, that an easement is such as, but not limited to, access easements, utility easements, drainage easements, or any other public easement. So the question is Pacer Lane, does that fall into one of those categories there under Article 2?
So, you know, it really is access easement, you know, to me, that's access to the entire subdivision. Is that right or wrong?
Well,
I mean, you know, what is an access easement?
and you've heard testimony from folks as to what they consider an access easement. I feel it'd be inappropriate for me to guide you one way or another as to how I interpret an access easement. I'm here to kind of guide through the process. You've heard arguments from both sides as to what they believe in access easement, and I'll recite what I understood them to say. Mr. Nestor had testified that an access easement could be granted to public or private, and it's an opportunity for, or it's something that's a restricted right of way for someone to gain access to separate properties. As I understood Mr. Epps and Mr. Caudle's argument, and please correct me if I'm misstating this, Bo, they more look at it as the access easement as defined by this statute must be public. If it's a private access easement, then it's not covered by this statute. And I don't think that, I didn't hear that Bo disagreed with Mr. Nestor's definition or understanding of an access easement, and they can be granted publicly or privately, but I think the difference in their opinions is whether or not this statute applies to a private access easement or a public access easement. And Bo, I'm happy to let you clarify if I misstated at all.
I think you said it very well. Mr. Epps's position is that if you read that provision of the ordinance, we agree that an access easement, generally speaking, could be private or public. Thank you. Okay, thanks. We agree that an access easement, generally speaking, could be private or public, sort of as a legal matter. We agree with that. And we think that's important because the list of things in that statute that are examples of the kinds of easements that the ordinance is intended to regulate ends with the phrase, any other public easement. And that phrase, any other, refers back to the things in front of it in that list. So when it says access easement, we think interpreting it and giving all those words meaning would require you to treat all of those easements as public easements. Otherwise, that phrase, any other public easement, is just really strange because you wouldn't say any other public easement. You would either say any public easement to conclude the list and you would omit other, or you would say any easement, period. Right?
Chaplain, anything to add?
Yeah, if I could clarify ours, we maintain that access easement is access easement. In his interpretation, is it's either. His interpretation is also the plat in reference was over this section of Pacer Lane, and it showed a dedicated public right-of-way in 3 different plats. And we also maintain it's had public use.
And, you know, I would say we don't have to clarify whether it's public or private. I don't necessarily think that if we say, if one group says that it's not public and they haven't proven it's not public, well, it hasn't been proven private either. So it goes both ways, but that's not our job tonight. It's, did Hunter apply, did he, you know, apply the ordinance correctly, and what was his interpretation? Sorry, let me, it says, so this, was there an error in application or interpretation? And I mean, we all helped write these, so in my personal opinion, it is, he did not, he applied it correctly, and his interpretation is, he didn't make any errors in his interpretation, because it's his interpretation, seeing that we all helped write these ordinances, so.
Yeah, and I have a problem with where I see, where in 1998, and then again, what was it in 2022, where you have different plats, I don't ever see where it says a private road. And again, I mean, if I look at, I don't want to throw eminent domain in here, but it's if the city wants to come through there and do something, they're going to do it. It's a public road, it's a public easement, and you go for it. this is extremely difficult. There is a major safety issue. Turnaround, there's very little turnaround room here. If you have a big fire truck, there's no way they're turning around in there without going over your lawn, all over the property, whatever. If it's muddy, they're gonna get stuck. So I get it. I've driven down Joe Carr Road, taken that left, come down. I get scared. I've been driving for over 50 years, and I still get scared driving down that road. And how many times, Hunter, have I said, why can't we get NCDOT to put some darn reflectors on there or lights so that we could see? Because I've been this close to having my car scraped and have a nice pinstripe on the side by, no offense, landscaping truck. But still, these are dangerous roads. People don't do the speed limits. There's a lot of problems here. So again, we're faced with here, putting a fence in the middle of a road. I'm sorry, I have a big problem with that. And again, we apply for a permit. That's one way to go about it, but just throwing it up there. I understand that the road, you look at the pictures and you see that there's water seeping up through there. It's a shame it's not Texas tea and we could all get rich off of that, but it's a big problem. These roads, you could see how deteriorated they are. And that's why I asked the question earlier, what's going to happen in the next 10, 15, 20 years? Mr. Williamson, you said you were living there 34 years and it's been bad like that forever, which I made a crazy comment. Let's just get rid of the asphalt and plant clover there and you just drive over it and go from there. But we have a difficult decision in front of us.
But
Well,
I think our decision, though,
It's very clear.
is very, very
Very
limited.
specific.
Finite, you know.
So can I ask the board 3 questions? Do you believe that this is a fence or a wall? And if you look at picture number 5 and 6 on Epps Appeals photos in eScribe, can you pull this up?
But we could all see if you
Okay.
guys-
There is a wooden fence almost into the center of the road.
Is that 6 to 8 feet?
It's a fence. I don't know what else. I mean, it is what it is.
Well, at one point, it was a complete fence across there, and
Right.
before Mr. Epps pulled it down and put the gate there.
Even with the gate, though, there is still a fence in the road. So it is a fence. So that is the answer to the first question. Yes, it is a fence. Was a zoning permit obtained to build the fence? No, that has not been contested. And do you believe that Hunter made an error in application or interpretation of the ordinance? And that's the third question. That's all we have to answer. So, really, it's
And
whether
the
or not
last part is the real, that's why we're here. Did he make an error? That's really the only question. Did he make an error?
And I'm sorry, just to be more specific, because we will have to issue an order on this, so I want to make sure we're specific. The question is whether, you're right, the question is whether Hunter made an error in his application or interpretation of the ordinances, but specifically, you did a good job of outlining those first two. I think the third one, a bit more narrowly, is in interpreting Pacer Lane as an easement as defined in Article 2.
One question, if whichever way the vote goes, if we uphold it, is he required to take the fence down? Or if we overturn it, he can keep the fence up, but if we uphold his decision, does he have to take the fence down?
If you uphold his decision, you all can discuss what remedies you would include in the order.
Which would be resubmitting a new application.
You heard Mr. Caudle request that one of the options be that, or he mentioned that one of the options could be allowing the Epps to submit an application or a permit application. That can be one of them. One of them could be removal of the fence or abatement of the fence. And I will mention, I think everyone's aware of this decision, any decision made can be appealed by Mr. Epps if he so chooses.
Well, and that's one of the questions, so, because there's a preliminary injunction out there that says, so it can't be locked. So, and I don't know how that ruling's gonna play out, but I guess that's not for us here to decide.
And that is specifically, though, for the fire marshals. I mean, like, that is their, you know, that really, yeah.
I think we got to come to a conclusion that if we, like you said, if we vote to uphold this, we can put restrictions on him. We would ask that he take the fence down. And if he wants to apply for a permit, it would. To do so, but do so by first, you know, taking the fence down. Put, you know, don't do it, you know, don't do it and apologize later. Let's do the right thing, take the fence down, apply for your, go about the normal steps that we were talking about, that everybody talked about today. And, you know, and then temporarily, everybody, you know, continue on if you want. If you want to continue this and deal with it, if we vote to uphold it, do so. But, you know, I would think, you know, take it down.
Right. Well, and the unspoken option would be for everybody in Marvin Estates to continue the negotiations or just talking about it, and how do you really come to a conclusion?
As a neighborhood.
To resolve the road, is right.
You know, beyond us is, you know, it would be, I'm not sure how many lots are. I'm not sure how many lots there are in Marvin Estates. I've been around a long time, but I never counted. But I could, you know, see, technically, they could be, if there are 50 lots, they could be 50 fences erected.
Yeah.
You know, if, based on that interpretation.
Potentially, yes. Okay.
Want to sum it up?
Sum up our discussion.
Yeah, I think.
Or come.
Yeah, come up with our opinion.
Do we just do straight up and down, do I do a statement of, in the affirmative and then up and down vote?
For this one, Jake, you can, your opinion.
And does this?
Normally I instruct them to make motions in the affirmative to essentially approve something and then vote it down if they want to vote no. In this case, would it be advisable to either move to uphold or move to overturn?
I think that's ultimately what makes the most sense, but. Oh, sorry.
I said that normally I instruct you all to make motions in the affirmative. That way, a yes vote is a yes vote, a no vote's a no vote. But I asked Jake in this case if it would be advisable to either have a motion to uphold or a motion to overturn.
Yeah, and I think that's right. I would like there to be some decision made before reaching that ultimate conclusion, the three questions that you posed. I've heard one or two folks say what they believe, but is this a fence or a wall? Has there been a permit obtained? And was Mr. Nestor's interpretation of the ordinances, was his interpretation that Pacer Lane is an easement under Article 2? Is that a reasonable interpretation?
All right, so would someone like to make the motion, or would you like me to do it?
Microphones, whatever microphones. Make sure your microphones are on.
We need.
Collectively do it.
And before we take the vote, and what is it to pass 4/5?
So much just pure.
4/5 is for a variance.
Just
This
majority.
is a straight up majority, so this would be 3-2 to be, you need 3 votes to pass.
So do we need 3 different motions for the 3
Nope.
questions? Or is it just
No, we need one motion.
one
Uphold or
motion?
overturned.
Yeah, that's what I was.
All right.
Well, I mean, if we agree, I think that we would make the,
Well, we'll vote with, and then
well, the first one would be
stipulate
to
options?
uphold. If we want to do it in the affirmative, I think the vote, from what I'm hearing, we would vote yea or nay, yes or no, should we uphold the
So-
decision?
I can do that.
Well, Austin, you okay?
Yes, Jake, again, should they move with a motion to uphold or to overturn?
Yes.
Okay, so just either say motion to uphold or motion to overturn based on what you want to do, and then that motion will go through.
Can we, I think you said we can add something to it if we uphold it?
That's, we can do that
That's,
after.
the order comes after.
That comes after?
The order, yeah.
So now
That's
it's just uphold or overturn. And so you want to make a motion to uphold, and we can vote on that?
And is it to uphold or overturn the notice, I mean, not the notice of violation, but the,
Uphold the ruling.
what is the actual language I need to use?
We got a couple wordsmiths in here, could you breathe them, I count.
You're gonna add it to e-scribe?
Okay, so
Thank you.
give
There we go.
me a starter motion here. motion to,
We'll go affirmative like we normally do, so motion to uphold.
to uphold. Jake, would you like to advise?
Yeah.
Keep our practices going.
Motion to uphold the findings of Mr. Nestor as to the violations of ordinance 2.13-2 subsection A and 2.13-2 subsection G.
Just to clarify, Marvin Development Ordinance subsection.
Correct.
Okay.
Yeah, sorry.
You're good. All right, so you hold anything saved? No, just save. So there is a draft motion in your system. You can use that to start.
Got to refresh.
Let me know if there's any changes you would like to make to the motion.
That's good with me.
Okay. All right, so I will make the motion. So the vote is to a yea or nay to uphold the findings of Mr. Nestor as to the violations of Marvin Development Ordinance 2.13-2A and 2.13-2G. Lucky you. Yay. Uphold.
Yay.
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 And Angel, sorry. Miss Alternative. All right, so
5-0.
the motion carries to uphold the ruling. So I think I will speak for the board because this is what I've heard you guys say. I would say that you should apply. You should just put an application in. I mean, I do think there are things that will be uncovered in that. I think the community has a lot of. Please silence all cell phones. Can you take that outside, sir? God bless. Just so the community is clear, as a government and as a planning board, we cannot honor covenants.
Board of Adjustment, not planning board in this case.
Just kidding, but you know, all of the above. The people who sit here, we cannot honor covenants. We cannot take those into consideration. We have to only look at our ordinances. So it really is a civil issue, and you guys will have to go and do. I would highly recommend that you seek an attorney to clear up some of these easement issues, because old neighborhoods, y'all gotta, it wasn't written when you were, when you were developed. So, so we would ask you to take.
But, yeah,
Not listening.
do we say, if he's going to apply for a permit, before he can do that, he's got to take it down?
Tomorrow.
Correct?
Yes, I mean, like that,
Yeah,
well,
I mean, you know,
that is what the ruling says,
Yeah.
is that it needs to be removed
And then you can apply.
for a,
Zoning permit. That would
for a
be,
building permit and for,
be our recommendation.
Yeah.
I can't ask, I don't guess I can't ask.
What?
Can I ask Hunter if he would also need to do a deed search on right-of-way easements before trying to? 'Cause this is really, this would be.
Yeah, let's let.
Yeah,
okay.
I think the order should be limited to the finding, which we have reached, the facts, which we've discussed, and then the remedies, which you've discussed a bit here. So one remedy is for Mr. Epps to apply for the permit, and I've heard that. There's been some discussion of him removing the fence before applying for a permit. I think you all need to be clear on whether or not that's something you want to put in the order, or if you want him to apply for the permit and set a certain number of days and decide on removal at another date. But I think there needs to be some clarity as to what exactly you want to put in the order.
I think we want to take it down.
Yeah.
We want to take it down.
I mean, it's in violation,
Yeah.
and you can't ask permission as long as you're in violation.
Right. We would like to take it down tomorrow.
And if it's a safety issue, then then that's a different process.
So I would put that in the order.
Okay. Is there a timing mechanism in which you all would,
You put it up in a day, you could take it down in a day.
well, and keep in mind, he'll have 30 days to appeal this decision. And I think that's worth considering when discussing the timeframe in which you give him to take it down.
I guess we could go a day and a half.
I don't have,
Yeah, I mean, one of the
suggestions was 10
Marcus was
days.
saying 10 days, and you're saying Mr. Epps has 30 days to appeal.
Correct.
40 days. So that would be 40 days.
Okay.
Days has November.
So as I understand it, the order will state that he will have 40 days from issuance of the order to take down the fence.
Wait,
Wait, why would he have 40?
Because there's a 30 day. he has
no,
30
we
days to
can,
appeal it.
even though he has 30 days to appeal, we can still ask him to take the fence down tomorrow, can we not? I mean, if he appeals it, he can appeal it, but why couldn't we ask him to take the fence down before the 30-day appeal?
You can ask him to do that. I think practically speaking, there creates a bit of an issue with if he takes it down and he appeals it and he wins on appeal, there just creates issues with taking it down, putting it back up, taking it down, putting it back up. If that's what you all would like to do, is do it in 10 days, you can put it in there. I tend to think that giving him the timeline in which he can appeal makes sense, but it's your decision.
But he's in violation.
Right,
It
I
should
mean,
have gone up in
Okay.
the first place.
We've already
without the proper-
decided
Mhm.
that we're gonna uphold, and we think it's a fence, we know it's a fence, we know it didn't apply for a permit, so what
It
we
needs to
did.
be done the right way, so
What
it
we
needs to
did
be taken
tonight
down.
was say, you're in violation, and
Right, but what teeth do we have, because you can't fine him for going past
I think,
whatever.
I think we're
that's-
asking him, I think we're asking him to do the right thing. I mean, we're not, I don't think we're saying if you don't do it, it's a remedy, we're saying, do the right thing. We all have kind of agreed on that, let's do the right thing here.
10 days.
Okay, what about 72 hours?
Doesn't take 10 days.
What do you want then?
It didn't take 10 days to put up,
I don't know. I don't know how long it took to put up, so.
I mean, let's be reasonable, what is this? This is a Thursday, Monday. That's what? Yeah. I mean,
72 hours.
he's either gonna do it or not. I mean, if we give him, he's either gonna take it down in 72 hours, or he's gonna take it down in 30 days, or he's not gonna take it down in 72 days, or he's
Moving the
not gonna.
metal gate shouldn't be that difficult, so you've
No.
got whatever, if that's a 4x4.
He's either gonna
sitting
do it
here,
or he's not.
You cut it at the bottom and then take off the 4x6s and.
You
leave the
just,
one
you
on the
unscrew,
side of
it
the
looks
road.
like it's a post, you just
Right, so it
unscrew
shouldn't
it,
take that long.
unscrew it from the, I could do that in an hour.
Okay, well, then let's just say 72 hours.
Yeah,
All right, done.
72 hours?
72 hours.
So the order is going to be that within 72 hours of issuance of the order, you're asking him to take down the fence.
That's correct.
And he has the opportunity to apply for the permit.
Both of those are
Question,
correct.
Jake. So the order being issued is actually when it is in writing and affirmed by the board, correct?
That's correct.
That
And
is not today.
that will not be today.
What, Austin?
This decision has to be in writing, and you guys have to vote to affirm it at a future meeting. It will not be issued today.
Good Lord.
What's not
I
gonna be,
have to round y'all back up in probably like however many days.
So-
That's the statute. It says you have to have a written
Permit is
decision.
slow.
Y'all have to,
Well, guide us then, tell
Well,
us
and it-
when.
Yeah,
it's
so the-
designed because y'all heard a lot of stuff, and an order's got to be written, and you really can't pre-prepare these. But that's the process that the statutes.
What would your guidance be then?
Yeah,
The-
so
The
we have to come back to
statute, the
adopt it.
statute provides that the order must be issued within 30 days or at the next scheduled board meeting, whichever is later. That is what the statute prescribes.
Which is Tuesday.
So They will adopt a schedule after this
We can put it back
hearing.
on the board.
Their next scheduled meeting, hold on. Their next scheduled meeting is August 19th. That's the one that's on the schedule.
Okay,
for the
sorry, can
Planning
we
Board and
just-
Board of Adjustment.
what is, procedurally, are we allowed to review things via email, or do we have to physically come in and hold an
This
official
has to
Board
be
of
voted
Adjustment?
in a meeting.
Okay,
So if it's 30 days or the next scheduled meeting, the next scheduled meeting would be on Tuesday, August 19th. We will be scheduling those meetings. Board of Adjustment meetings are scheduled to be concurrent with Planning Board, so we would come in, do Board of Adjustment business first, gavel that in, gavel that out, and move on to Planning Board. So as of right now, if we could move if we move to do the next scheduled date, it would be August 19th.
and if we were to do a special meeting for the 15th,
That's a lot more paperwork.
Well, no, we just canceled the meeting.
That's a Planning Board meeting, that's not a Board of Adjustment meeting.
but we're all available, well,
Yeah.
I'm not, but the rest of you are, so.
You guys have another thing to consider. Special meetings have to have so many hours' notice, so many days' notice. You're coming up against that now.
Yep, okay.
From a clerk standpoint, I prefer not to do that short of notice. That's going to be most of my day tomorrow and Monday, just getting this ready.
Okay, all right.
Well,
So then we need to do it to one day. One day. If we can't meet till August 19th.
what'd you say?
One day.
Y'all, I'm sorry, that's crazy. That's crazy. We're gonna have, tell us how soon we could meet. How soon can you help us meet? Because waiting until August is
Okay.
not okay for the.
What's the reasonable amount of
neighbors
time
this-
for the order to be written?
Well, August 19th is also beyond 30 days.
I thought it was whichever was later.
I think you're supposed to.
Is it earlier or later? I thought it was later.
Well, they don't want to, I don't think they want to wait that long anyway. So,
No.
72 hours is shorter than.
We came down from 10.
Well, you've heard our recommendation now. Obviously, it can't be done, so
It's 72 hours from the issuance of the order. I need to know how long it takes to write the order.
get it done in a week. I mean,
Yeah, the order will take at least, I'll have it done by next week.
All right.
How much time do you need, Austin, realistically? Not you spend the next 2 days. but-
Legally is 48 hours in
48,
advance. 48 hours in advance of the meeting. The special meeting notice has to be issued.
Now tell me what realistically for you to schedule it.
72 hours.
well, that's what we said.
Give me an extra day to get everything in order. If the order's not done till next week, that's going to push us into the week of the 21st to the 25th. I'm out of town.
Okay.
I'm not here, so it can still be done. It'll be Ptolemy that'll be here for that meeting. I personally would recommend going with the last week of July, the Tuesday, the 29th. There's nothing going on here to my knowledge except coffee with council in the front room, so. Tuesday, July 29th would be my recommendation.
I'm out of town, too.
You're out of town?
John's out of town, I'm out of town.
Hunter's remote that day, too.
I know Marino's out of town.
Um,
He's out of town till August 11th. Last week is horrible.
Let's say Tuesday, we'll figure out a way to make it work. Tuesday, the 22nd. That would be the earliest.
I'll make it work.
Okay, I actually just thought of a way to make this a lot easier. So the next thing you guys will do after this is adopt your schedule. We will amend the schedule and put this as a regular meeting date on that schedule.
Okay.
We have enough days in between for that to count, so. We're gonna amend the meeting, we can amend the meeting schedule, say August 22nd will be the next meeting of the Board of July 22nd will be the next meeting of the Board of Adjustments. You guys can affirm the decision at that meeting.
Let me ask you the question, if one of the five of us who were members tonight can't make it, does Angel move in, or does it have to be the same five?
That's a good question, one that I've never had to answer.
That is a good question.
Why you gotta be so tricky?
I
You'd
do
only
not
have
know
to.
the answer to that.
I do from some of the municipal law, the board is a board as a whole, and a new board can even vote on minutes and to approve things from a prior, and you would only have to have a majority vote anyway to adopt the order of the decision.
So as long as there's 3 votes of the board in the affirmative, you can affirm the order. So any 3 votes.
Okay.
All right, so if one of us are here not on the 22nd, Angel can step in and be the board.
Correct.
Okay. Then
And since,
Are you here on the
Michael, since
22nd?
you stepped in today, the
Right.
next time an alternate is needed, it's Angel's turn per the rules procedure. And then it alternates back and forth until the point we lose.
So no more
lose
coin
track.
flips is what you're saying?
Huh?
No more coin flips?
Unless we lose track.
Okay.
All right, is everybody good with that?
Yep.
The 22nd,
here,
we'll do
Angel?
6 PM.
Because I don't think I.
We'll officially amend that, we'll officially adopt that amended schedule in a few minutes. Jake, what else is needed on this matter right now? Anything? Nope. So we're good to move on? Yep. Okay, we are good to move on to other business, the adoption schedule.
All right. So because we have an attachment, would so these are just proposed. So like if there is a hearing that needs to happen, it would happen on one of these dates.
So like any other board, you need to have a regular meeting schedule. Without a regular meeting schedule, we're having to call special meetings for every meeting of the Board of Adjustment. The dates that are in front of you are today's date and the planning board, the same dates as the planning board for the rest of the year. So we're just scheduling those meetings concurrently. We're going to add a date in between today's and the August meeting for Tuesday, July 22nd at 6 p.m. specifically for this reason.
Okay.
And any other business that happens to come up in it.
So very similar to when we were switching our DRB and PB hat.
Yeah,
So
we
that-
close out.
That night will only be Board of Adjustment.
But normally, yes, if there is something, then we would switch hats, so.
Okay.
So then the motion would be to adopt the 2025 Board of Adjustments meeting schedule with, as amended.
We'll make a note in the minutes that schedule, that meeting is added, and we will post an official schedule probably tomorrow or Monday with the updated dates. And
Okay.
do all the legal stuff we gotta do.
All right, so the motion is to adopt the 2025 Board of Adjustment meeting schedule as amended.
So moved.
All in favor?
Aye.
All right. Done. And do you need to do the adjournment? Hit the gavel, dude.
Keep them with tradition. I move to adjourn.
All in favor? Aye. Thank you, everyone.